Equitable. Alright, 110. Alright, there we go. So we're merging them.
Yes,
Money,
merge those two titles.
banking,
You got it.
and trust by moving titles in commerce. Featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Welcome, everyone, to this Saturday, July 17th, 2010 edition of Money, Banking, and Trust by Moving Titles in Commerce. I'm your host, Christian Walters, and welcome to NTT as New Trust Technology, and we'll go to the disclaimer next. Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein reference, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Again, I'd like to welcome everyone to this Saturday, July 17th, 2010 edition of NTT as New Trust Technology. And we're on Book 90 of Corpus Juris Secundum, and we left off last time on page 96, section 193, beginning on the transfer of estate or interest of City Key Trust. Page 96, section 193, transfer of estate or interest of City Key Trust. So in general, the estate or the interest of a beneficiary may ordinarily be alienated or encumbered by him, but he may transfer and the assignee may receive only such interest and right as he has in the trust. The estate or interest of the City Key Trust in the trust property may ordinarily be alienated or encumbered by the City Key Trust without the assent of the trustee. For such interest or estate is separable. The City Key Trust is not under disability. Subject to some limitations, the foregoing rule has been applied to contingent as well as vested estates and interest, and to future as well as present interest, where, however, to permit alienation of the interest of the beneficiary would be destructive to the trust and incompatible with its purpose. There is no power of alienation, although no restrictions on the power are expressed in the instrument creating the trust, and such conveyance or transfer disappointing the purposes of the trust and diverting the property from the named purposes constitutes a breach of trust. The beneficiary's assignment of his beneficial interest under a trust is not the assignment of a choice in action, but of a right, title, and estate in and to property. A person has capacity to receive or transfer of the beneficiary's interest under a trust to the extent that he has capacity to be the beneficiary of the trust. Next section, interest transferred. The beneficiary of a trust can transfer or convey, and the assignee can receive only such interest and right as the beneficiary has in the trust. and this is true of a transfer by inheritance. Thus, conveyance of a Seti Key trust passes only his equitable estate or interest, and he cannot convey the legal title to the trust estate, except that he may be empowered to do so by the trust instrument. But any legal conveyance by the Seti Key trust will have the same operation in equity would have in law on a legal estate. The right of the person who is both the beneficiary of the trust and the owner of the remainder to dispose of the remainder or reversion of a fund is not, however, limited or qualified by the fact that he is also the beneficiary. If the owner of the beneficial life interest created by the trust carves the person thereof and transfers it to another, such transferee then also becomes an owner and part of the life interest. Where the property is conveyed in trust, the income thereof to be distributed to the various beneficiaries and the trustee having power to sell and invest, a beneficiary has no interest in any specific property which he can dispose of. Whether an assignment is intended to transfer with it the beneficiary's right to receive the principal proceeds or provisions and circumstances of the assignment. Next section, claims against beneficiary and subjection to trust. The transfer of beneficiary takes subject to valid claims against the beneficiary under the trust, and as a legal title is in the trustee, the purchaser of the Seti Key Trust's equity is held to take full notice of and subject to all conditions imposed by the trust instrument. Since assignments of the equitable interest in trust are held in funds held by the trustee or subject to the equities of the trustee arising from the notice of the assignment, a loan wrongfully made to a legatee by a testamentary trustee from the trust funds without notice of a prior assignment by the legatee of the interest in the estate can be retained by the trustee from the amount payable to the legatee or his assignees, irrespective of whether the amount advanced is a loan to the legatee or an advancement under the share due him from the estate. The assignee of the remainder interest in the trust, who takes the knowledge that his assigner is also a trustee, takes subject to subsequent as well as prior equities between the trustee and the estate and cannot claim the remainder free from the burden of the trustee's debt to the estate. Next section, manner of effecting transfer. A manner in which the beneficiary's interest under the trust may be conveyed or transferred depends on the terms of the trust and the scope of the case, and a valid transfer may be effected by will or inheritance. The essential elements of a valid agreement or assignment must ordinarily be present, and the transaction must be free of fraud, mistake, or undue influence. Since the assignment of an interest under a trust is not the assignment of a truth in action, as appears above, such assignment is not affected by the beneficiary's endorsement of a note to the alleged assignee. Next section, necessity and sufficiency of consideration. The transfer or assignment by the beneficiary of an interest in the trust may be by gift or in consideration. An attempted assignment by a person of his unassigned interest in trust for the benefit of another cannot be sustained as an engagement that the property should belong to the assignee when received in the absence of a consideration. One claiming under an assignment of part of a trust fund in litigation, in his answer to the petition filed therein, should show the facts as to the consideration of the assignment. In the absence of appearance in the action by the assigner, after due notice, the assignment will be held absolute for adequate consideration. Evidence is admissible in an action by the assignee of a beneficiary to secure his note against a trustee to sequester such income to show failure of consideration for such note. General rules apply as to the sufficiency of the consideration for the transfer or encumbrance. Next section, construction of assignment. Rules governing the construction of instruments of assignment or conveyance generally have been applied in construing instruments assigning or transferring the interest of beneficiary of a trust. Next section, notice by assignee. Notice by a prior assignee of an interest in a trust estate to the trustee is essential in against a subsequent assignee for value and good faith, and without notice for the reason that the prior assignee's failure to give such diligence and would permit the assigner, through his apparent ownership of the trust fund, to defraud subsequent purchasers. And a trustee who takes payments of beneficiary's interest from the trust fund either to the beneficiary or a subsequent assignee without notice of a prior assignment is protected as against a prior assignee. However, the recordation of the mortgage on real estate of an instrument which is a mere assignment by the beneficiary of funds in the hands of a trustee does not operate as constructive notice of the assignment. Next section, invalid trust taking effect as power. Where a trust for an unauthorized purpose can take effect only as a power in trust, the right of the intended beneficiary to enforce the execution of the power in equity is assignable, and the assignee enforce the execution of the trust power in equity in the same manner as a person for whose benefit it was created. Next section, partition. A city key trust who is under no disability and whose trustee joins with him in an agreement for partition with all parties interested in decedent's estate is bound by such agreement. Next section, B, restrictions against alienation. The beneficiary may not alienate or encumber his interest in the trust insofar as it exercises this right is restricted or forbidden by the trust instrument or statute, but the rule does not apply to trusts created by the settlor for himself as beneficiary. Continuing on, the estate or interest of a city key trust in the trust property may not be alienated or encumbered insofar as the exercise of this right is expressly or impliedly restricted or forbidden by the instrument creating the trust, or insofar as there are applicable statutory provisions which so operate, and to the extent that a conveyance or assignment violates such a restrictive or prohibitive provision, it will be invalid and convey no rights. In fact, such a spendthrift trust is protected from liability for breach of contract as from the enforcement or the enforced performance of an invalid contract. Whether the settlor intended to restrict beneficiaries' power to alienate or anticipate the benefits of the trust depends on the intention as determined from the provisions of the instrument creating the trust. A limitation on the right to assign income has been held not to preclude an assignment of the where it has been paid over to the beneficiary free from restrictions at the termination of the trust. Next section, discretionary trust, trust for support. Where the trustee has given discretion as to the payment to be made to the beneficiary cannot alienate his right to such benefit, and it has been said to be the nature of the beneficiary's interest rather than a provision forbidding alienation, which prevents a transfer of such interest. Under such a trust, a transferee of the beneficiary cannot compel the trustee to pay over to him any part of the income or principal. However, it is only to the extent that the trustee is given discretion that the right of alienation is restricted. Similarly, there are trusts where the trust provides that the trustee shall pay or apply only such of the income and the principal, or either as is necessary for beneficiary's education or support. The beneficiary cannot transfer his interest, but it is otherwise where the trust, although intended to provide for beneficiary's education and support, provides for a specific amount to be paid or applied by the trustee, or is otherwise not so limited. Next section, creator as beneficiary. While it's been held that unqualified spendthrift provisions in a trust agreement are intended to apply to the settlors in his capacity as beneficiary as well as to other beneficiaries, it is more commonly held that the spendthrift provision in a trust are inoperative as to the trust created by the settlor for himself as beneficiary, so that he can alienate his interest notwithstanding such spendthrift provisions. Thus, where the discretionary trust or a trust for support is created by the settlor for his own benefit, his transferee can reach the maximum amount which the trustee under the terms of the trust could pay to the beneficiary or apply for his benefit. Right at time of distribution of trust. Next section. Where all the beneficiaries are alive at the time for distribution of the trust and there are no provisions, no previous assignments, the beneficiaries are not subject to any spendthrift provisions of the original trust and can transfer their interest as they please. Next section, 194. Alienation of income in anticipation. Income from trust property may be alienated by the beneficiaries before it becomes due, except insofar as alienation is forbidden by the trust instrument and the trust was created by one other than the beneficiary. Subject to statutory inhibitions and regulations, as discussed infra 195. The trust provisions restraining alienations considered below, the income from trust property may be alienated by a beneficiary before it becomes due. Thus, the provisions of agreement of the assignment of income, where such assignment is valid under statutes and trust provisions, is binding on the transferee. and where there has been no failure of consideration on the part of the assignee, there can be no basis for rescission by the beneficiary. Whether or not an agreement or transaction is one to alienate the beneficiary's interest under the trust depends on the terms and provisions of such agreement or the circumstances of the transaction. Where an assignment made by the income beneficiary of a trust has been satisfied, any surplus of accumulated income remaining thereafter is payable to the beneficiary. Next section, restricted provisions and spendthrift trust generally. In the case of trust containing restraints against an alienation of income, frequently known as spendthrift trusts, a beneficiary cannot alienate the income therefrom before it becomes due. However, the extent to which the alienation of income in anticipation is barred or restricted depends on the provisions of the particular trust instrument. The restriction applies only to income which may thereafter accrue, and the provisions of a spendthrift trust against the alienation of income does not limit the right of a beneficiary to dispose of income which has reached the hands of the beneficiary, or which has accrued under the trust. Hence, an assignment of income under a trust has been held to be valid insofar there may be accrued income in the hands of the trustee at time of the assignment or trustee's notice thereof. At the most, a purported assignment of the future income of a spendthrift trust amounts merely to the direction of the payment for future sums as when they actually accrued, and such direction is revocable by the beneficiary at any time as to future payments. However, payments of future income actually made by trustee after their accrual and pursuant to the unrevoked authority or direction are valid and discharged in trustee's obligation. Next section, discretionary trust. Trust for support. Future payments discretionary with the trustees of a spendthrift trust are not assignable. It has been held that the beneficiary under a trust for support from income does not have an interest which is assignable. It has also been held that the alienation of income is limited by implication by the trust for support, insofar as it would be incompatible with the purpose of the trust, but the restriction against alienation will not be extended beyond such requirement. Next section, spendthrift trust created by beneficiary. Settlor of full legal capacity cannot, by establishing a spendthrift trust in his own favor, forever deprive himself of the power to transfer the trust property, except by giving to another person such an interest therein as will give the other person by standing to enforce the restraint. Accordingly, the provisions of a spendthrift trust forbidding alienation and anticipation do not apply to a trust created by the settlor for his own benefit, and the settlor beneficiary may voluntarily transfer his interests. Next section, assignment by beneficiary to his wife of income from personality held in trust is valid, especially where it is acquired by the wife in the line of a bequeath. On her agreement properly to care for, educate, and maintain their infant children, it has been held that the beneficiary of a spendthrift trust cannot, by a property settlement and incident to the divorce, assign a portion of the interest in the income of the trust to his wife, but a provision in the spendthrift trust which require the trustee to hold the principal and income for the fund free from all claims of creditors, and which provides the beneficiary should have no power to anticipate, charge, or encumber the principal fund or income, did not preclude the beneficiary from assigning to his wife a half interest in the income of the fund, and it accrued and became payable for her support that over the minor children. Next section, 195, statutes restricting alienation of income. Under statutes providing, a trust beneficiary cannot ordinarily transfer by assignment or otherwise his right to receive income from personality or rents and profits from realty. It is a rule in some jurisdictions under statutes to that effect, enacted in accordance with public policy, as to the indestructibility of the trust, that the right of the beneficiary to enforce the performance of the trust to receive the income of personal property, or the right to receive rents and profits of the real property, and to allow such funds as to use of any person cannot be transferred by assignment or otherwise. Under such statutes, a life beneficiary of rents and profits of realty under an express trust has no estate or interest in land as such can be mortgaged, and the rule of common law that the beneficial interest under a trust may be alienated by beneficiary discussed through sections 193 and 194, and that it is subject to the claims of creditors considered infra section 197 is abolished, and as such statutes, being in derogation to the common law, must be strictly construed and will not be construed as application to trusts other than those specifically designated. However, legislative policy cannot be defeated by an action of a court permitting such alienation or abrogating the trust. Moreover, the Sedekey Trust cannot indirectly accomplish such alienation by any consent through estoppel which he may give to a conveyance by the trustee. It is not essential to make the statutes applicable to the trust to be a sponsor of trust, and the effect of the statutes is essentially to convert every trust within the scope into the sort of sponsor of trust. The statutes become applicable only after the trust has been set up, and the instrument will not be construed as transferring or assigning the income of the trust in violation of the above statutory provisions unless such construction is absolutely unavoidable. Since the statutes were enacted to compel the carrying out of an intention of a person creating the trust and not to frustrate such intentions, they do not prohibit the handling or termination of the trust in accordance with the trustor's intention. Moreover, the statute of prohibition is no application to the right of a beneficiary other than those specified by the creator of the trust as the recipients or beneficiaries of the trust income, and hence alienation of the right to transfer income granted solely by statute and not any direction of the creator of the trust is not prohibited by the statutes. It has been held that the beneficiary's revocation of trust, as distinguished from a transfer or assignment, is not within the statutory prohibition. A beneficiary who is prohibited from alienating or assigning his income may nevertheless subject it to a claim for legal services rendered to enforce his rights. The inhibition of the statutes is inapplicable where the trust is created for the benefit of the settlor and where the holders of the beneficial interest have an interest in the trust funds or corpus as well as the right to income. Next section, transfer of accrued income. The above statutes do not prevent a transfer or accrued interest or a direction subject to revocation for the payments of income as it accrues. It has been held that any attempt transfer of future income by the beneficiaries amounts merely to a direction for the payment of future sums as they accrue, subject to revocation at any time as to payments not made prior to any such revocation. An agreement by a beneficiary to turn over the income of a trust as it is paid to him has been held not to violate the statutes to be valid. Whether the beneficiary's directions authorize the trustee to turn over or apply to another accumulated funds or anticipated income depends on the provisions of such directions and the circumstances surrounding their issuance. Next section, provisions for payments of principal annuities. While the trust clearly within its meaning is not withdrawn from the operation of the statute because of the incidental power to add principal to income when necessary to provide support and maintenance, the rule is otherwise, and the trust is not within the statute, where payment from principal is obligatory. It has been held that gifts of specific amounts payable out of both income and principal are not within the statutory prohibition. An annuity payable under a valid express trust cannot be assigned or released by the annuitant under the statute prohibiting transfer of income payable from the trust by assignment or otherwise, but where the annuity must be paid out of principal if the income, rents, and profits are insufficient when the statutory restrictions are inapplicable. Next section, restraint limited to support. In some jurisdictions under statutes to construe it, has been held that the restraint against alienation is limited to the extent necessary for the support and education of the beneficiary as gauged by the pre-existing station in life, but that the surplus is alienable, notwithstanding the restraint contained in the trust agreement. Next section, 196, resulting or implied trusts. The beneficiary of resulting or implied trust can transfer or mortgage his interest. The beneficiary of resulting or implied trust has the power to transfer his interest or mortgage it, and such transfer or mortgage is binding transaction. Thus, a Sedekey trust entitled to a beneficiary interest in land purchased by another with funds belonging partly to the former may alienate his interest under the trust, and the trust may be enforced by his grantee. Under the statute of uses, a purchaser who buys land with his own money and takes a deed to a third person is the legal as well as the equitable owner and may convey in his own name. A judgment recognizing plaintiff's equitable interest as trust beneficiary under an applied trust does not cancel plaintiff's deed conveying the legal title. Next section, directing conveyance to another. Where a resulting city key trust is of a full age and under no disability and is entitled to a conveyance, he may direct as it to be made to another, and the whole title will thereby pass. Next section, 197, rights and remedies of creditors of city key trust. The interest of a city key trust in trust property is ordinarily subject to claims of creditors, at least if it is a vested and determinate interest with a right of present enjoyment and of alienation. In the absence of provisions to the contrary in the trust instrument, as discussed infra section 198, or of statutes as considered infra section 199, and the interest of city key trust in trust property is subject to claims of creditors, at least if it were vested and determinate interest with a right of present enjoyment in severalty and a right of alienation, and the beneficiary is not under disability. It is true of a trust fund whether the trust is created by the debtor himself or by a third person. However, where the city key trust has no present right of enjoyment or power or of alienation, his interest cannot be reached by his creditors, although if the estate is vested and the fact of quantum thereof is to some extent dependent on the contingency of no objection to a sale of the corpus of the owner's debt, and the mere fact that the interest of a beneficiary of a trust is a future rather than a present interest does not prevent his creditors from reaching it. The interest of the beneficiary's wife in a trust is subordinate to the alimony claim of a divorced former wife as a judgment creditor, and the fact that a third person accepts a deed to the trust realty does not convert the estate from the purpose of the trust agreement or render such person personally liable for debts of the beneficiaries on the ground that he has preferred himself personally as a creditor. Next section, time of inception of claim. It is immaterial whether the beneficiary was insolvent or in debt, debted to the judgment creditor when the trust was created, or if the debt was incurred thereafter. Next section, trustee as creditor. If the trustee appointed for the purpose of protecting the trust property from the debts and extravagances of the city key trust encourages his extravagance and waste by lending him money and becoming his surety and otherwise becoming his creditor, the trust property cannot be subjected to the payment of such debts, especially where the trustee is authorized to sell for reasonable and proper expenditures. Next section, limitation to interest of beneficiary. The creditor of a trust beneficiary has no greater claim in the trust fund than the beneficiary, and can subject no one in the trust estate to the debt then the debtor is entitled to demand from the trustee. Thus, in order that the interest of the beneficiary may subject the claims of creditors, it is essential that it be such an interest as could be enforced by the beneficiary himself. It has also been held that where a beneficiary does not own the right to alienate the trust property, his creditors cannot reach such property. After a beneficiary has made an assignment of all his property, no interest remains that may be subjected to his creditor's claims. Under a will creating a trust and directing that income therefrom be paid to the use of the testator's son and family, and providing that the trust fund be held intact until a certain time, after which the remainder of such funds should be delivered to the son and his wife, and the son acquires no alienable right of reversion that is subject to the judgment lien of his creditors. Next section, possession by beneficiary. The fact that a beneficiary is allowed by the trustee to live on and operate a farm constituting part of the trust property and manage and take care of the stock and appropriate the avails for the support of himself and the family does not constitute such a surrender of the property to the beneficiary as will subject it to the claims of his creditors. But it has been held that where the trustee has allowed the city key trust to occupy the land and make contracts with respect to it, he was the landlord, and the rents were liable towards his debts. Next section, under passive or dry trust, the estate of the city key trust is liable for his debts and is subject to levy and sale under execution against him and to the lien of a judgment against him. Next section, joint deposit and trusts. It has been held that the power to withdraw from a joint deposit and trust for the depositor as joint owners subject to the order of either with the right of survivorship is not joint, but exists completely in such beneficiary as reserved personal right, which no creditor of either can exercise or compel the debtor beneficiary to exercise, since a valid trust, untainted by fraud, may not be ended at the instance of a subsequent creditor. Next section, 198, spendthrift trust and trust for payment of income, etc. In many jurisdictions, effect will be given to the settler's intention to create a spendthrift trust, and income of which is protected from the creditors of beneficiaries. Exceptions may be recognized in such cases as surplus income, accrued income, and trust created by the beneficiary. A trust may, in the absence of statutory restriction, be so created to protect the income, rents, and profits of the trust estate from creditors of the beneficiaries of the trust, although the beneficial use and enjoyment of such income, rents, and profits are expressly granted them. In some jurisdictions, it is settled that where either by provision, express provision or by implication of the like of all the circumstances, it appears to have been the intention of the creator of the trust to pay to or apply for the benefit of another the income of the property or a portion of such property, that the interest of the beneficiary should not be subject to the claims of his creditors. Such interest cannot be reached by them. But in other jurisdictions, in the absence of statutory authorization, this mode of limiting the liability for debt is not recognized, it being held that the only manner in which the creditors can be excluded is to exclude also from all benefits from or the interest in the property by such limitation on the contingencies of his bankruptcy or insolvency as will be determined which will determine his interest and make it go to some other person. In any event, it has been held that there must be something in the face of the instrument indicating the purpose of the creator of the trust that the interest of the beneficiary shall not be subjected to the payment of his debts. And in the showing, it may be so subjected under proper proceedings that the revenue arising from the trust is directed to be paid directly to the beneficiary without direction as to the application or without any discretion being vested in the trustee as to the time and the amounts of the payments or the purpose for which they shall be applied. Thus, ordinarily, where the income is payable absolutely to the beneficiary, the trustee having no discretion, it may be subjected to the claims of the creditors, at least where it has become due and payable, and where under the spendthrift trust property is given absolutely to the beneficiary on arrival at a specified age, but his possession and control, as well as his right of alienation, are restricted until that time, and on his earlier death, just claims of the creditors may be paid from the trust property as well as from other property he may have owned. On the other hand, a spendthrift trust is created, protecting the trust and the income thereof from the beneficiary's creditors, where the property is held in trust to receive rents and income thereof and to apply such rents to income to the support of the city key trust or the city key and his family. The policy of the law is recognizing a spendthrift trust does not extend to claims against the fund out of the trust of which the trust is created. Thus, the remainder interest in the corpus of the trust after the expiration of the trust, which contains the spendthrift clause provision, is not within the scope of such provision and may be reached by the creditors of the remainder man. If the income is to be applied for use of the city key trust, a court of equity may direct application of it to the payment of the debt, as that would be an application of it for his use. In the event that the property passes to the beneficiary of a spendthrift trust free of the trust limitation, it is liable for the beneficiary's debts. Income from a spendthrift trust which is placed beyond the reach of the creditors of the beneficiary has been construed to be beyond the reach of the settler's estate as creditor of such beneficiary. Next section, restraint against alienation. The fact that the beneficiary is restrained by the trust instrument from alienating his interest in the trust does not necessarily preclude the creditors from seizing the income therefrom as it accrues. Next section, discretion of trustee. Where the trustee is given discretion as to the payments to be made to the beneficiary, the interest of the beneficiary is not such as may be reached by the creditors, and it is the nature of the beneficiary's interest rather than the provisions forbidding alienation which prevents the creditor from compelling the trustee to make payment to him. However, there is only where the trustee has discretionary power to withhold from the beneficiary all payments or beneficial use, that the interest of the payment may not be subject to his debts. Next section, surplus. In some jurisdictions where the rents and profits of a trust property are in excess of those needed for reasonable support of the beneficiary, the surplus can be subjected to the claims of his creditors. But in other jurisdictions, in the absence of statutory provisions, therefore, it is held that the surplus cannot be reached. Next section, payments to beneficiary, accrued income, accumulations. Even though a trust instrument provides that the income shall be exempt from liability from the debts of the beneficiary, the income, when paid to the beneficiary by the trustee, becomes part of the beneficiary's general property, is not protected from the creditors. Thus, although the will provides that the income of property devised in trust shall be exempt from liability of debts of the Seti Key Trust, is solely for his use and shall be paid to him on his receipt. Such income, after it is paid to the Seti Key Trust in accordance with the will and deposited in a bank by the latter, is liable to execution against him. However, where the trust is created for the support of the beneficiary and his family, the income of the trust is not subject to the claims of beneficiary's judgment creditors, even after the income has been paid over to the beneficiary for the support of himself and his family. On the other hand, it has been held that the income of a sponsor of trust, which is already accrued in the hands of the trustee, but which has not been paid to the beneficiary, is exempt from claims of beneficiary's creditors, at least where the beneficiary is not assumed a dominion over it, either by making the trustee a depositary or otherwise, where the trustee is given discretion as to the time, manner, amounts of payments of the income. Accumulations in their hands cannot be reached by the beneficiary's creditors. Next section, beneficiary's right having of disposition. Where the beneficiary is given the right of disposition, his interest is subject to the claims of his creditors. Accordingly, if the instrument creating a sponsor of trust provides that the Seti Key Trust or their assigns can have a conveyance of the trust property on their joint request in writing, the trust property is not exempted from the claims of creditors. On the other hand, it has been held that although the beneficiary has power to require the trustee to pay over the whole or part of the fund to him, until he has done so, his interest cannot be reached by his creditors. Next section, creator as beneficiary. When cannot, by creating a voluntary trust for himself, protect his income from his creditors, even though the trustee is given unlimited discretion as to the use of the property for his benefit of the Seti Key Trust, it has been held that the same rule applies where the trustee has discretion to expend the funds for others, since he could still pay it all to the settlor. If a debtor pays a consideration for a sponsor of trust in his favor, his creditor can resort to the property bought, and in any event where the death of the settlor, the contingent remainder interest in the principal become indefeasible vested in the remaindermen, they cannot be reached by the settlor's creditors. However, it has otherwise been where husband and wife as tenants by the entireties conveyed property and trust, reserving the life estate in themselves with the remainder to their children. And this is so even though they reserve the power of revocation, since the judgment creditor of the surviving spouse cannot compel such spouse to exercise the power to revoke the trust, insofar as the sponsor of trust created by the beneficiary debtor is of the same reason void. The judgment creditor has the right to treat the property in the hands of the trustee as though it belongs wholly to the debtor. Next section, trustee as beneficiary. Where income from trust property to be managed by several trustees is to be applied to the use of one of them, the management of its application is not controlled and directed by the Seti Key Trust, but by a majority of the trustees, and such income cannot be reached by the judgment creditor of the Seti Key Trust, at least until, by the death of the custodies, it becomes under his control. However, where by the act of one of the custodies, co-trustees, income is created to the beneficiaries in the beneficiary's own account, such funds lose their immunity under the sponsor of trust. Next section, claim for maintenance of beneficiary. Where a trust provides an annuity for the support of an incompetent beneficiary, the trustee may be required to pay a claim for reasonable value with support and necessities furnished to the beneficiary by another with the trustee's knowledge and without his objection. So where the trust fund is to be applied in support of the beneficiary, a claim for medical services rendered on the request of the beneficiary with knowledge of the trustee may be enforced in equity as against the trustee where the beneficiary is insolvent and does not appear that the trustee has furnished him with all the necessary with respect to medical attendance, where the loan was made to the beneficiary to supply him with the necessaries before the will creating the trust had been found on his mortgage of a supposed interest in the estate. Equity could direct the application of the income of the trust fund to the repayment of the loan, especially in view of the statute authorizing the court having jurisdiction over the trust estate to require the application of the trust funds or the income thereof to the maintenance or education of the beneficiary under some circumstances. Where public authorities are permitted to, by statute, to recover for the maintenance of the beneficiary in the hospital for the insane, a trustee may be compelled to reimburse them from the trust, but they cannot recover for an outlay prior to the creation of the trust where the trust fund has not at any time become invested in the beneficiary. Public authorities cannot recover for the support and care of the inmate of a public institution where the trust providing for such inmates' comfort support intended that the funds should be used to supplement the care and support furnished by the authorities. A written agreement between the beneficiaries of a spendthrift trust and a claimant who rendered nursing services to him, providing for a payment for such nursing services, is not binding on the trustee and cannot serve as the basis of a claim against the trustee's estate, particularly where the trustee is not notified of such claim or agreement until the death of the beneficiary. Next section, claim for support of wife and children. It has been held that the interest of the beneficiary of a spendthrift trust or a trust for support can be reached under some circumstances in satisfaction and enforceable claim against the beneficiary by his wife or child for support, but has also been held that the rule protecting the interest and principal of the spendthrift trust from the claims of creditors of the beneficiary applies as well to obligations for support money. The subjection of the trust fund to the satisfaction of an order or decree in divorce proceeding for alimony or support of minor children is discussed in divorce section 272 and section 321E1A. Next section, attorney's claim, contingent fee. The employment of an attorney on a contingent fee based on the beneficiary of a spendthrift trust for the purpose of investigation and litigation as to such trust funds as ineffective to support the attorney's lien or claim on the basis of an assignment by the beneficiary as to any interest as such fund or income thereof, and where the beneficiary had already paid in cash retainer fee commensurate with the services rendered by the attorney, the trust funds could not be liable for the further fee either by contract or to a quantum merit basis. Next section, assignee of receiver appointed in proceedings supplementary to the judgment obtained against an income beneficiary of a trust acquires no greater right under the assignment than the beneficiary creditor had, and where the assignments of future income under a trust are by statute not assignable, as discussed supra, section 195, the assignee acquires no rights. Next subsection, death of beneficiary. The protection afforded to the beneficiary of spendthrift trust will not extend beyond his life, except in as far as the will otherwise provides, so that the creditors of the deceased beneficiary of a spendthrift trust are entitled to reach the funds, including the corpus of the trust, in the hands of the personal representative, even though the will makes no provision therefor, since the law compels such payment regardless of such omission. Income accumulated at the time of the death of a beneficiary under spendthrift trust, but not paid to him, will be payable to the executor and is liable to claims of his creditors. Next section, 199, statutory provisions. A, exempting interest of beneficiary. Under some statutes, cases in which the trust fund proceeded in good faith from some person other than the beneficiary are exempt from statutes providing for liability for the debts of the beneficiary. Under statutes to that effect in some jurisdictions, Cases in which the trust fund proceeded in good faith for some person other than the beneficiary are exempt from the operation of general provisions, which the interest of the beneficiary of the trust may be subjected in equity to liability for his debts. Such a statute operates to deprive a court of equity of any jurisdiction which might have otherwise have had to subject the interest of the beneficiary, and the exemption is affected by the statutes regardless of the restrictions stipulated by the founder or creator of the trust. Under such statute, property or income in the hands of the trustee of a trust created by a will cannot be reached by creditors of the beneficiary, although the beneficiary has also charged as executor with the administration of the trust. However, such a statute, when construed in connection with another statute, rendered a surplus over which is necessary for the education and support of a person for whose benefit a trust in income is created reachable for his debts, discussed infra subdivision B, number 2 of this section, does not prevent creditors from reaching such excess. Moreover, such a statute does not apply where an attempted trust is invalid, and where a statute so provides, the trust must be declared by a will duly recorded or deed duly registered. Under some statutes to that effect, such trusts have a partial exemption and are subject only to partial appropriation. Next section, express exemption of the trust for support. A statute making express provisions from the exemption of an income or expense through a trust to be up to a certain amount has been held to apply to a trust to receive such pay profits annually or oftener for the support of the maintenance of the city key during his life. Next section, prohibition of alienation. Under a statute prohibiting alienation by the beneficiary of his own right to receive income, discussed Super 195, it has been held that the beneficiary's income and interest in a trust fund cannot be seized or levied by his creditors. The rule applies although the beneficiary has become entitled to the estate in remainder. Under such a statute, a power of attorney given by the beneficiary to his creditors to collect the income in order to discharge his debt is invalid. Next section, dry or passive trust. The statutes exempting trust property from liability for benefits do not apply to a mere dry or passive trust, and that part of the trust income has already accrued and is ready for distribution, and the beneficiary is subject to seizure. Next section, trust established by debtor. The statute exempting a trust income from liability for creditors' claims does not apply to trust income from a trust established by the debtor, and the creditor is entitled to reach the entire interest of the debtor without regard to sufficiency of the fund to support the debt. So also the various statutes expressly or implied to granting the exemption of a trust fund providing for support do not apply to cases which the settlor is himself the beneficiary of the trust. B, subjecting interest of beneficiary. Under various statutes, the interest of a beneficiary in the trust is subject to the debts where the statutory conditions exist, and liability for support of his family may attach even though the trust is a spendthrift of trust. Under a statute providing that estates of every kind held or proposed in trust shall be subject to the debts or charges of the persons to whom use or whose benefit they are held or possessed, where the beneficiary whose interest is sought to be subjected is given an enforceable interest in the property devised that interest may be subjected to its debts. Such an interest is given when the specific sum is directed to be paid to him, which payment he can legally enforce, or where the language created in the interest is sufficient to give him an estate and property devised. It is also even though the trust instrument vests discretion in the trustee as to how the management and control of the estate. However, where neither of these is given and the sum which he is to receive is discretionary with the trustee, no interest is created which may be subjected to the payments of the debt, for the creditor cannot subject nothing more in the hands of the trustee than the beneficiary could, since the creditor stands in the beneficiary's shoes. Under such a statute, where a trust is to pay the net income of the land to the beneficiary for his support and support of his family, and the trustees are given power to sell the land and apply the proceeds and income therefrom in the same way, the beneficiary has no interest in the land which can be reached. where the trustee has the absolute duty to pay the income to the trust to the beneficiary, he cannot defeat the claims of the beneficiary's creditors pursuant to the statute by overpaying the beneficiary. It has been held that the creditor's right under this statute to subject the property of the beneficiary to payment of the latter's debts is superior to the beneficiary's rights under the trust agreement, so that the beneficiary's interest may be subject to payments of the debts, even though the testator or grantor provides otherwise. Under some provisions, the creditor is only entitled to reach a specified portion of the income. Next section, a statute conferring the right on creditors to reach equitable interests of the debtors has been construed not to apply to trust for the maintenance and support of the debtor or his family, under which the trustees are given discretionary powers, whether the discretion is as to the use of the corpus of the trust or as to the income. Next section, right to withhold income as test. By statute in some jurisdictions where property is given to trustees to pay over the income to any person, such income is liable in equity to the claims of the creditors of the beneficiary if there is no provision for the accumulation of the trustees are not expressly authorized to withhold such income, and it is not expressly given to the support of the beneficiary or his family, although if any of the conditions specified is present, the income is not liable to the claims of the beneficiary's creditors. Authority given to the trustee to expend the income as he may see fit for the beneficiaries instead of paying it over to them constitutes a withholding of it. Next section, income due and owing. Under a provision permitting an execution against income from a trust fund due and owing to the judgment debtor in excess of a certain amount, the beneficiary cannot be regarded as having income due and owing where the trust is to apply income to its support and the support and maintenance of his children, he not being entitled to any of the rents, income, or profits of the trust estate, and under which any surplus not required for support is to be paid to others. Next section, support and maintenance of wife and children. Under a statute expressly so providing, trust income is liable for and subject to the support and maintenance of beneficiary's wife and children under certain circumstances, notwithstanding spendthrift trust provisions in the trust instrument, at least in the absence of provision of the trust deed manifesting an intent to the contrary, although the interest through the liability may be limited to a specified percentage of the income. A statute subjecting income under a spendthrift trust created by a person other than a beneficiary to payment for the maintenance of beneficiary's wife and children has been held invalid as applicable to trusts created before its enactment, although it has been held to the contrary that income accruing after the passage of such a statute may be subjected notwithstanding the trust was created before its passage. 2. Surplus. Under some statutes, a beneficiary's interest is liable for his debts to the extent that there is any surplus over the amounts necessary for his support, which includes to support himself and his dependents in the mode which they have become accustomed by express provisions of the statutes in some jurisdictions. In the case of a trust for the payment income in which there is no valid provisions for an accumulation, any surplus over the amount necessary for the education and support of the beneficiary is liable to the claims of the creditors. Such a statute, while in terms relating to trust of realty, has been applied to trust of personality, although under some statutes it has been held that the statute does not apply to trust of personality. The remedy under such statute is not confined to the accrued income, and the court may determine what is reasonable allowance and direct application toward payment of the judgment or any further surplus. In order to avail himself of such statute, the creditor must bring himself within its terms and, as appears infra, section 200D, show the existence of a surplus. However, whatever income is allocated or paid to the beneficiary of a discretionary spendthrift trust, the amount necessary for the beneficiary's reasonable support is completely exempt from the claims of the beneficiary's creditors. It has been held that when a surplus has been found to exist, the amount thereof becomes an overriding lien on the entire trust income, and the sum applicable to the beneficiary and his dependents collectively is deceased by that amount, decreased by that amount, excuse me. Next section, determination of sum necessary for support and surplus. The amount exempt under the statutes subjecting to the liability of beneficiaries' creditors, the surplus over the amount necessary for the beneficiary's education and support varies according to the beneficiary's station in life and includes an amount sufficient to support himself and those dependent on him according to the mode to which he and they have become accustomed and to the care for any affliction from which he or any of his family may be suffering. Earnings and income of the beneficiary from sources other than the trust cannot be considered in determining whether there is a surplus within the meaning of the statutes. A claim of the wife of a beneficiary for alimony is to be deducted from the surplus income before it may be applied on a judgment against a beneficiary, and an order of the court requiring trustee to pay such alimony is paramount to the rights of creditors to subject such income to judgment recovered before such order was entered. Next section, revocation of trust. As a trustee in bankruptcy is entitled to reach the surplus, if any, beyond the needs of the bankrupt for the education and support, it must follow that the consent by the latter to a revocation of the trust indenture would be the tantamount to a fraud on his creditors where such surplus exists under a statute whereby surplus income from trust property was subject to claims of the beneficiary's creditors. Next section, territorial limitations. A statutory provision by which a surplus rents and profits of real property held in trust may be subjected by beneficiaries' creditors applies only to land in state in which the statutes were enacted. 200, proceedings to subject interest of beneficiaries. I think we'll stop there and we'll pick up there on page 119 next time. Section 200, proceedings to subject interest of beneficiaries. So we'll go to the Q&A.
Q&A session started.
And press star 6, star 1 to raise your hand and get in the queue line. Press star 6, star 1 to raise your hand and get in the queue line and ask a question. Dan, you're unmuted.
Hey, Christian. Hey, I talked to you for the first time probably, I don't know, about 3 weeks or so ago. I was a brand new listener. Since then, I've done nothing but sit and listen to your past recordings religiously, and I've become become pretty educated on your on your stuff. And you're absolutely right. The trust is the core of everything. Once we unlock that and understand that, we can, live more truly free. However, I've come to a point in my studies where I need something of a study group. I don't know if, I think that you have a Skype group, but I don't know how to get on it. I don't know where to go to share documents and stuff with other people. Can you guide me in a direction, please?
Yeah, if you give us your Skype name so we can get you into the group.
Fantastic. It's Freeman, one word, Freeman, and then Dan.
Okay.
And then once you get me going there, all my other questions I can ask on the group and let other people come up. However, there's one more request I have of you. Whenever I'm explaining this stuff to people, I am explaining to them that everything that we do is a trust, including buying gas. However, I cannot explain to them how buying gas is a trust. And
don't too bad.
Can you basically, in layman's terms, explain that real fast? Because that'll help me to explain to other people, and it'll help unlock more of my brain.
Well, a lot of people, if we try to wake them up, just like in the movie The Matrix,
Exactly.
If you try to wake them up before their time, they will fight you.
Yes.
It's like you're talking to people like talking to a wall. It's like they're staring at you like deer in the headlights, They got no idea what you're talking about. Although that doesn't prevent you from maybe, just trying to see if their mind's open to it, because some are, some aren't. And usually the ones I find that are more interested in paying attention to what you're saying rather than telling you what they know, those are the ones that are in a situation now they're put between a rock and a hard spot, and they're looking for an answer.
Right.
And usually a lot of people with foreclosures and stuff, you know, they're prime candidates for some of this stuff. But those people that do not have a problem, they're not looking for any answers.
I agree. I completely agree with you. It doesn't matter what you're talking to them about, whether it's trusts or fluoride in the water. If they're not willing to listen.
They got a comfortable life. They don't have any problems, and what you're telling them is like, I don't really care.
Right.
But, you know, it just comes down to a basic understanding of, you know, we have no money.
Right.
Because the Constitution says that we're supposed to have lawful money, and we don't have constitutional lawful money of a specific weight in gold and silver.
Right.
If we have no money, then we can't pay anything. If we can't pay anything, then we can't complete a contract. So I can't give value for consideration. You can't do an equal trade here. So if we can't complete any contracts, then something has to fill the void. Trusts fill the void perfectly, because to transfer property in a trust, you don't have to have a conveyance. It's a gift. And we're gifting everything without restrictions in a trust. That's what's happening today. That's taken the place of lawful money. Now, if you can explain that to them, you know, there's a lot of connections and dots there.
Yes. Well, that's basically where I go with them, explaining that to them. And some people listen, other people say, yeah, okay, whatever. I can always trust on you to talk about some crazy stuff, which is fine.
Yeah. Don't feel bad. Join the crowd.
Exactly. I don't have a problem with that. I'm used to that, actually. But one last thing before I jump off here. Creating the title. I sat down today and I found a border for a bond. I took a description of my Tundra outside, you know, just exactly. I patented it after another title that I've got here in the house. When you say create a title, is that what you mean?
Yeah, you're actually doing a survey of the vehicle. You're listing a description, you know, how much it weighs, maybe, you know, just basically what they do. That's a survey.
Okay, and so I just
specific number on it, a VIN number.
Right. I did that. I didn't list it as VIN number either, because it's a vehicle, which vehicle has a certain.
Well, I stamp my own number on it, stamp an RA number on it somewhere.
I do own 28 or 29 more RAs. It's not a bad idea. Okay, and then I printed it out on bonds paper. Do my wife and I need to sign that?
I would get somebody who's owner to sign it, and then get 2 witnesses.
Okay, owner and 2 witnesses. Well, me and my wife would be owners of it, because yeah. All right, that's all I need to know. I'll get the rest from the group. So yes, please list me down on your Skype group. I can't wait. Christian, you're a godsend, man, and I'm trying my best to teach other people what you are teaching, but I have to learn it first. So, anyways, I'll jump off cue. Thank you, my friend.
Okay, what was your Skype name again? One more time.
Freeman Dan, as in Dan is a free man.
Okay. Yeah, keep in mind that I have only 2 groups. One group is strictly private, and that's for the trust ambassadors. And another group that is welcome to NTT, Christian Walters group, and that's the one you'll be invited into.
Okay.
And any other group other than that is not associated with me.
Okay. Makes sense. And right here on the public record, I agree to any and all of your agreements. I will not use your documents for any type of trouble, only for my personal education and whether or not I decide to used in with no repercussions upon you.
That's fine, as long as it bears fruit. That's all I'm interested in.
Exactly. All right, bud. Thank you. Appreciate it.
Okay, Dan. Thank you. Okay, press *6, *1 to raise your hand and get in the queue. I believe there's nobody else up on the board, so we got an empty board. So.
Hi, Christian.
Hi, Floyd.
Hi. I got a little action going, and I just got a question because it was my traffic ticket that I had a light that was out. I think I've mentioned this before. Anyway, when I went to, I called the court, and I asked them how much it would cost to put in a counterclaim, and they didn't know what I was talking about yet exactly. So anyway, I got a hold of somebody in the court, and that had a little bit more understanding, and she said, "Oh, you want to put in an appeal because the judge had found me guilty." Didn't even I didn't even I didn't even get a chance for a hearing, basically. I sent in my paperwork, and I was told that the judge would look at the paperwork, and then he would give me a decision. So he sent back a decision of guilty. So I was going to do a counterclaim, and when I talked to the court, she said, "Well, you want to do an appeal?" And I said, "Okay, how much does an appeal cost?" She said, "Nothing." And I said, "Well, what if I want to put in some instructions with the appeal?" She said, "Well, just whatever you want to put in with the appeal, you attach to it." So I'm going to put in my mandamus for, what's it called, a mandatory injunction. So anyway, and I'm going to put a mandatory injunction in equity in. But when I do my paperwork or make out my brief or whatever you call it, you know how you divide the paper with little line, and you put plaintiff on one side and defendant, and then you put the case number on the other side. When you're doing an appeal, do you have to put the case that you went to court with in the first place underneath, and who the plaintiff and the defendant were on that one?
The best way to explain that would be to go to your local rules and find out where your appeals court is, because they have a rules book that goes along with the whole setup there and explains it all.
Oh, well.
It's basically like you were in a case before.
Oh, okay. Well,
With the heading on it. But it'll explain it in the rule book there, and every state's a little bit different. So.
Well, it's a little weird because I don't have any plaintiff and defendant that was given to me. All they did was took the traffic ticket and charged me and asked me for money, but they didn't put down a case or a case number or anything.
Mm-hmm.
And all they have. Well,
maybe when you file the appeal, maybe they assign a case number.
Well, what if I call the court and ask them who the defendant or who the plaintiff was?
Yeah, I imagine it was the municipality or whatever it was.
Yeah, because all it has is that it's a ticket from the police department, and the police department's not. They're not the plaintiff.
Right. Let's see. There's something I was going to ask you. I forgot what it was. Let's see. Something about your filing. Oh, I know what it was. Did you ask for a hearing?
Actually, no. Actually, what I did was I called the court, and I asked when I would I sent in my trust res and all of the information on the trust, and then I called the court and I asked them when if my case or if the I asked if the debt had been extinguished, and the lady said, well, the judge looks at the paper, or she said he looks at the cases on, and mine was going to be on the 12th. She said it'll be on the 12th, and she said then call in on the 13th and see what his decision was. And that's all she said.
Well, that's kind of like an ex parte hearing. You didn't have a chance to be heard.
I know that. That's what I mean. There was no, they didn't say come in, or they said if this block is checked, you don't have to show up, and
So there was no date set for a hearing. You didn't ask for a date for a hearing.
No,
there was no hearing, but yet the guy they found you guilty, huh?
Yeah. It said that.
Well, it isn't a communistic state, I'll tell you that.
Well, it said July 12th was the date, was the court date, but then when I called in, they said, well, you don't have to show up, and so I just put in my paperwork, and that's and I put in the I put in my trust paperwork. So now. Now September 21st, I have an appeal date to show up for the appeal. So I'm putting in my mandatory injunction for the 21st, and I am setting it's giving me some practice on what to say. Let's see. I can find. Okay, what I have. Let me see if I can bring it up. Okay, what I'm saying is notice is hereby given without waiving any right, remedy, or defense. Whereas I, Floyd Bradley Howell, am competent with intent and purpose as grantor settler of the expressed revocable modifiable trust herein filed in good faith and with all rights to right, title, and interest, states as follows. The previous proceeding was contrary to equity. A trust is cognizable only in the private side of equity as there exists no adequate remedy at law. The debt is extinguished. Grantor hereby invokes mandatory injunction. Let's see, I got two other points that I made and it doesn't show up here. Anyway, let me see here something once.
How much time do you have?
Oh, I got until September 21st. And I got lots of time to do it, but I wanted to put this in. Well, actually, I've got a week to get this in. And I don't know what happened to my, to all of my, let me see here. Now, let me go into my files, because I had 5 points that I had put here. Let's see. Let's see if this one's it. No, I must have deleted something. Doggone it. Ooey. Well, anyway, let's see. Just hang on a second here.
So you only have just a week to get this in and put that in your record?
Yeah, I have to get my paperwork in for the hearing, and then my hearing is on the 21st. Let's see.
Well, maybe we can go on the call later on and maybe discuss it a little farther.
Okay, because I put in that the previous proceeding was contrary to equity. A trust issue is cognizable only in the private side of equity, and there exists no adequate remedy for relief at law. And then I said the debt is extinguished, and that the grantor hereby invokes mandatory injunction. And there was a couple other things that I had said, but I don't know why I.
Okay, what is like the focal point of the main thing?
The focal point is, well, I would say the focal point is that I'm really basically I'm asking for a mandatory injunction to.
That's got to be based on something, and that should be based on the main thing.
Yeah, I had 5 points, and I.
What are the 5 points basically? Can you condense them?
They basically were saying that that the judge I didn't say he was in breach of trust, but basically I wanted to give them a colorable explanation as to why I needed to get into camera.
Okay, what would the colorable explanation be then?
The debt is already paid, and he's asking for payment again, so that would be unjust enrichment. That could be one.
So are you stating that in one of those 5 points then?
No, I didn't, but that's a good point to do it.
So do any one of those 5 points state that it's already been paid?
Yes.
Okay. Which one is it? Read that one.
The debt is extinguished.
All right.
That was the term I used. I could have said the debt is paid, I suppose. That would have been more colorable.
Yeah, I would say that with the debt was extinguished with discharge.
Okay.
Basically, that's the claim. It's already been paid. So by the time you get in there, you'll probably have a. Did you send them an opportunity to cure, to correct it? Did you have time to do that?
No, I didn't, and I guess I probably didn't think about doing that because when I asked to make a counterclaim, the lady said, "Oh, well, what you want to do is an appeal." And so that seemed to be the way that they wanted to handle it. So I figured, well, I guess as long as I can get before a judge.
Well, here you want some colorable stuff. This is what I would throw in there. Number one, violation of due process due to constitutionality, because you did not have a chance to be heard, period. You were not even there. It was an ex parte hearing. Ex parte means that you were not there.
Right.
You had no opportunity to defend yourself whatsoever. That's a violation of due process. And that's what I would be coming at them with right there. That'll get their attention. That's something they're going to see.
Yeah. Well, they're probably going to say, well, that was your choice. You could have come in. And then,
did they send you any kind of notification of a specific time, specific place for a hearing?
Well, they gave me, it was on the ticket. It said that that it would be, that there would. Well, let me read you the ticket. Maybe that'll explain it. Okay, on the ticket it says, You are summoned to appear in the County of Prince Edward General District Court Traffic, 111 South Street, Farmville, Virginia, on July 12, 2010 at 11 a.m.
So you had notice.
Yeah, so it says you may avoid coming to court only if this block is checked, and that block was checked, and all instructions on defendant's copy are followed. So so that's why I sent in my paperwork, thinking that was because that's what, when I called up, that's what they said that I could do.
Yes, but what you did by checking that block, you waived your rights.
No, they checked the block.
They checked the block.
Yes.
For your authorization, though.
Yeah, I signed it as grantor beneficiary, though.
Or when did you check mark the block? When you got the ticket?
Yeah, when they gave me the ticket to sign, I signed it grantor beneficiary.
So you didn't fill out that block. The guy gave you the ticket did.
Yeah, right. No, I didn't fill out the block. They filled out everything. The only thing I did is I just signed it.
All right, so he waived it for you then. Well, see, you need to put an objection in the court right away. Object that the signature was signed in there, and it was not your intent to waive your right. You need to get something in there right now as fast as you can. This is a notice of objection in opposition. Write that down. Notice of objection in opposition.
Okay, just hang on a sec. That's my heading?
That's your title of the document, yeah. It's a motion that goes into the court. It's a notice of objection in opposition, and then you explain in there what the points are. That it was not your intent to waive any right, and this guy checked it for you. Because actually what they've done is they've lured you into waiving the right to a hearing, and then found you guilty, and now you got to pay. And even if you go to appeal, you'll still lose.
I see, okay. Okay, it was not my intent to waive any rights. And then the guy...
You wanted to have a hearing so you could be heard and defend yourself.
So I'll just put, I was led to believe that I did not have to show up.
Not believe. It was not my intent.
Yeah, right, I got that. It was not my intent to waive any rights.
Right. And then you claim a constitutional violation of a due process that you didn't have a chance to be heard and defend yourself. And you just realized your mistake now because they were mistaken.
A constitutional violation not to be heard?
Yes, you had violation of due process. You didn't get a chance to be heard. So you could defend yourself. And you just now discovered the mistake on their part because they're mistaken. These are key words I'm giving you. Mistake.
Right.
And it's a mistake on their part because it was not your intent to waive your right to a hearing and to be heard.
I realized their mistake. Let's see. Okay, I realized their mistake was made. How do I say that? I realized their mistake that was made.
I'll give you the key points, and then you can kind of put it together, and then...
Okay. Now, when I put this into the court, is this something that I'm just going to have to pay some money to put in again, or how does that work?
Say that again, Floyd?
Do I have to go down and put and pay to put this into my case, or is the case considered open yet, or how is that usually?
Yeah, I would consider it still open yet. Yes.
Yeah. Well, yeah, because I have to make the payment by sometime next week. So I'll put this in instead.
Well, what about this appeal?
Well, I can put I can put that in. I can put that in next week too. But if that's not going to get me any remedy, if that won't get me my relief because of the fact that they can say, well, you could have shown up.
Yeah, because you should have shown up at that date. Yeah.
Yeah. But I was led to believe that if I put my paperwork in, that was all I had. Well, that's basically what she said. Was that the judge looks at this on the, on the 12th, and he'll let you know.
Yeah, well, he let you know, all right.
Yeah, well, yeah, because I thought, well, the fact that I claimed trust and then I gave him all of the information for the trust, I thought that was going to take care of it. But obviously, it didn't. Okay, so it was their mistake by signing that, by checking that box.
Yeah.
Okay. It says you may avoid coming to court only if this block is checked and all instructions on defendant's copy are followed. So they checked the box, and then they expected me to do whatever it says on this thing on the back here.
Yeah, to make out the payment and send it in.
Yeah, it says the final outcome of your case rests with the court and is a matter over which neither the arresting officer nor his department has any control. You are presumed innocent until proven guilty beyond a reasonable doubt. You have the right to hire a lawyer. You have the right to have the clerk issue subpoenas to require witnesses and blah, blah. You have the right to plead guilty or not guilty or nolo contender to any charge placed against you. If convicted by the district court, you have the right to appeal within 10 days after trial. By signing the summons, you have certified to your current mailing address. Official notices will be mailed to that address, blah, blah. You must notify the court of any change. If the court has been notified of a change of address, official notices will be mailed to that address. If you fail to enter a written or court appearance, you may be tried in your absence. If found guilty, the court will impose sentence. In addition, the Virginia Department of Motor Vehicles or the licensing authority which issued your driver's license will be notified of all convictions pertaining to the operation of a motor vehicle. Your failure to timely pay fines, costs, and fees imposed upon a finding of guilt will result in suspension of your driver's license and Virginia driving privileges. So on. Well, the fact that I sent in my trust information showing them that this was a trust should have at least let them know that there was something going on here out of the ordinary, but obviously it didn't make any difference to them.
Right, right.
So I thought in my appeal, I would just tell the judge that, that I had claimed trust, and I can't discuss any of the pertinent information unless we go into camera.
Well, see, probably on appeal, there is no hearing. It's a trial de novo based on no information other than what was in the case to begin with. Well, let's talk about this a little bit later. Let's maybe move on to some of the other callers then.
Okay. All right. Alrighty.
All right, Texas, you're unmuted.
Hello?
Hello.
Hey. Wow, man, I tell you. You can hear me now, though, right?
Yeah, this is Albert.
Yeah.
Hi.
How you doing, man? I'm sorry about that. There's like 4 buttons I have to press, and a couple of them were star 6s. I don't know. I didn't know which ones I got. Anyway,
Well, you made
I've got I've got a problem here, Christian, and this person, in my opinion, did a dumb thing. Well, it was an accident, but still. They sent some serious documents to a person, and now that person that they used to converse with, they told me, acts like, they don't live there, they don't act, they don't answer, they don't pick up, they don't send email, etc. And the serious documents is, just about the most serious you can possibly get. And I was just wondering if you had any suggestions for something like that. Maybe this should be taken on a private call in order for me to clarify what I'm talking about.
Yeah, it's more or less, it's the basic model NTT to take the dead offer and put the asset with it and return it back as merged, as extinguishment for the payment.
Well, it has something to do with that, Christian. It's the woman accidentally mailed the wrong envelope to somebody. The envelopes were already stuffed by the husband. And, one was going one place and the other one was going another, but as far as the woman knew, this one was the one, and she sent it to this guy. But that envelope contained just about all the ID you can possibly have in this country. And now they can't seem to get anywhere. The guy lives in another state. And when they told me about it, I only had one idea, but, I'm stupid. My name is Stu, by the way. And I had to, throw this one to you to see what you thought. Let's say, let me put it like this. So let's say Floyd sent his most beloved documents to someone he thought was a friend, and then once time went by, enough time for, I guess, delivery, postal delivery, he doesn't hear from that guy no more. And, Floyd would be up in arms on this. What can a guy do?
Do they have proof that they mailed such and such documents?
It was just mail, regular mail. In fact, 2 stamps, I think it was.
Well, the only thing I could say would be that you're going to have to make a formal notice and demand and get them back. And if you can't get them back, then you have to take some kind of action or something.
Now, this is what I had stated, and if I misstated, tell me. I told them...
Can these documents be replaced?
Sure.
Well,
yeah.
She lost them and go get them replaced, and then... this person that got the documents, is there any way that they can use these documents to hurt their person's detriment or something?
Possibly. I tell you what it was. This man was going to use his documents, one from the state, one from the federal, along with some, I think his bank account, to try and do a form with the feds to get rid of his number. The feds wanted that kind of information according to what he says. All right. But he hadn't done it yet. He was still thinking about it. He had the form in there with his 2 documents. And then on the other hand, the other envelope contained a simple letter where they were going to send $10 to this person for a DVD. So what the woman did was she just stuck the 10, licked it, put the stamps, mailed it. And, you know, it took about 2 days, and then they realized, hey, you sent the wrong ones. So 2 weeks had gone by. This guy was conversing with the guy, asking him if he had gotten this thing, and the answer was sentences down to a couple of words, down to 1 word. And this is the way he told me. A sentence down to just a few words as a reply to whether or not they received the letter. And then when he told me it finally came down to 1 word, I go, he got it. I go, I just know human nature, and, you know, that's the way a person would react if they were planning to stiff you. You know, sentence, no, they haven't gotten it, probably was true. Couple of words once the time was getting closer, but when it's 1 word, oh yeah, he got it, and now he just does not reply. Now, he also told me the guy was sick a month ago, vainly sick, not critical, but real sick. And I probably believe that. And I told him, well, look, could he be sick, have gone to the hospital, and that is why there's no reply of anything. The possibility is 50-50. Okay, 50-50. The guy has no family, so there's no one to contact. And like I said, there's serious documents where, you know, you could sell those documents in the black market, I'm sure, for, you know, 4 or 5 figure digits, I don't know. I'm just guessing. But, you know, since the guy is unraveled and the woman is beating him with a stick, you know, he threw it to me, and that's as far as I could go with it. I do have a couple other moves, but they're only pawns and a horsey. I got no queen or bishop moves on this.
The thing I would say is, you know, you need to be double checking before you do stuff. Don't make mistakes.
Right. So now that the
trying to correct a problem, and I really don't know what to tell you. I can't, you know.
I know. I was just throwing it out there, just seeing, you know, putting feelers out there. See what you thought.
Other than a notice and demand for what you sent them back, and then bring some kind of formal claim against them for, you know, they didn't give you the documents back that you sent to them, but, you know, I don't know how enforceable that would be.
No, I wouldn't think it's enforceable at all, to tell the truth. I mean, the guy, I told him that he could just deny, he got it. But when he also, there was also a key to this on the address, and that key to the address tells me a lot that I can't really talk about. But I needed to hear what you thought about it. And there's another move I thought the guy could do, and that is, look, if you think he's sick and nobody's replying, nobody's answering, I go, maybe he's on the floor, deathly ill. You know, call 911. Shoot. Nobody, you know, he has no family, he has no friends. Call 911. I mean, what if he croaks on the floor because you didn't move? And, you know, I didn't want the guy thinking that it could be all negative, that maybe he is sick and he can't get to the phone, he can't do anything. Maybe he's just completely incapacitated.
Yeah, yeah.
Well, that's basically my question, and without putting too much on this guy, because sometimes he gets on your call and I don't want to embarrass him.
Okay.
But I know that he's too embarrassed to talk about it right now. Anyway, appreciate it. And I've been studying material. You know, I go back several months and I'm going through that stuff. And, oh, man, I tell you, you know that word bingo you keep using every once in a while?
Which word?
That word bingo that you use a lot?
Yeah.
Well, it's mine now. I start listening to your stuff and I go, bingo, I got it, man. So I suggest to everybody, you know, go back, do some homework. You know, don't let this call be the only work you do, and don't let your experience be the only, you know, the only thing you got. I mean, go back, hear it again, and I guarantee you'll be saying that 5-letter word.
Right. All right.
Thank you, man.
Okay. Thanks, Albert. Tammy, you're unmuted.
Oh, that must be me.
Hi, Tammy.
Hi. I chimed in when Floyd was talking, and I just thought, geez, Floyd, you know, they're just running the realm of commerce on you. If he had a date of the 12th and he didn't put something in and go put it face-to-face with the gal and at the clerk's office and, you know, put something short and sweet in there like estoppel due to unclean hands or, and I thought trial de novo, and then you spit it out, so that was it. It was like, dang, they just, you know, they just proceed, especially when it comes to traffic issues like that, or, you know, it's just commerce as usual. It's just, you know, go forward. So that's all I had to say. But you took the words right out of my mouth, so irrelevant.
Okay.
But anyway, so I'm just, you know, it stinks because Floyd's issue was little, but now it feels like it's heavy and big, and he should just take it lighter and hammer him, you know, because it gets frustrating, especially on a little issue like that you have to do all this paperwork. But, yeah, a date went by, and that's what happens. They just proceed. Like you've said many times, commerce runs you over because she's presumed to be the trustee with a duty to pay. End of story, right?
Yeah, I guess so, yeah.
Yeah, so kind of sucky because it's not a big deal, but it's feeling now to him like it is. But that's all I had at this point. We had a heck of a storm here. Oh, my gosh. I was going to get on the computer to call in, and we had yellow conditions in the sky and lightning and thunder and all this crap. So I'm back to the phone dialing. What do you do? Anyways, I'm back out listening. Hang in there, Floyd. That's all I got to say.
Okay. Thank you, Tammy.
Talk to you. Bye.
805, California, you're unmuted.
Hey, good evening. Thank you for taking my call. This is Jeff from California.
Hi, Jeff.
Hey, Christian. Let's see. My first question, I guess, if you're involved in an action that's in equity in the public, that is obviously after the 1933, so it's really not the same equity, right? Because equity blended with admiralty law. Is that correct?
Yeah, there's a different equity floating in the courts after 33, yeah. They say it's equity, but no, it's really statutes and codes.
Right, so like an injunction action that falls under equity there still just statutes and codes. It's statutes, really. It's not
yeah,
even
the
a thing.
Rules and regulations, yeah.
Yeah, okay, so that really doesn't get you into a court of equity, essentially, even though you're in supposed equity. It's still special pleadings and the NOI that gets you into the equity that we're looking for.
Yeah, you got to set those switches in the pleading and then get in chambers hearing to present your substantive evidence there.
Yeah, they did. And as far as the Form 56, is that pretty much necessary to assign a trustee, for example, in a court case? I mean, is that part of your evidence, part of your...
Yeah, you could use a Form 56, but you really don't need one. You could do an appointment any other way, just by the letter of appointment.
But I guess, is that like a witness also that you have to have the IRS notified and things like that?
Who are you trying to appoint for this? For what?
A judge. A judge. A judge in a case.
Yeah, 56 form you could do. You could use a 56 form, but. Yeah.
And then also the concept of the non-negotiable instrument and using the original charting instrument and converting that into a non-negotiable instrument.
That's the equitable asset. That's the special deposit.
So, yes. I have a couple questions, if you don't mind. Can I go into that?
Yeah, that's general, because general is a negotiable instrument versus special is a non-negotiable instrument. There's your public and private.
Okay, so
general, which is negotiable instruments. Private is special, which is non-negotiable instruments.
Okay, well, I understand that. So basically, an instrument in the case is the actual charging instrument. Now, that's pretty much what's moving the court. Now,
the debt title, yeah.
Yeah, that's the debt title. Now, if you wanted to convert that, merge titles, your signature basically on that debt title, along with some other relevant information, will turn that into merge the contract, essentially. Merging title.
Yeah, I'm treating that signature as an equitable asset, and that's going to be applied towards that debt title.
Right.
So that signature is actually the equitable title, the equitable asset title.
Now, in my case, I know for a fact that I can just go into the courthouse and go into the department, and they'll grab the file, and they will hand that file to me. I will get the wedding signature file, and I can have that in my hands. Now, I can do that in the public, but not in court session. For example, the court won't be in session. The clerk will just be working in there, filing paperwork, whatever. And I can go in there, and because if you want to get a certified copy, you can do that. But you can also go up and look at the original file, and they'll pull it out for you, and they'll just hand it to you. Now, I was considering, turning it into a non-negotiable instrument before the case even. Now, would that be a breach of trust doing that? It's essentially in the private because the court's not in session, but I would be doing it in the courtroom just while the clerk was minding their own business, doing their own paperwork. I could probably go in there, make it into a non-negotiable instrument, and hand the file back to the clerk, and the clerk would be none the wiser. Now, would I do that on the wedding signature page of the district attorney that's bringing the charges as well? Does it matter which page you do it on, front page or the signature page?
Since you're the one who put the signature on the thing originally.
Well, no, I did not. The instrument is the charges, and the district attorney that filed them against the straw man.
Yeah, I understand that, but they have your signature on file by they're putting your signature applied to that by combination signature rights as the special or as the general deposit.
Okay.
General deposit. So now I forgot what I was going to say. The signature. What was it? Got off track there.
Sorry.
Oh well, let's go on. It'll come back.
All right. So I was just talking about making it into a non-negotiable instrument before I'm even really asking the judge for a hearing, before I even have a hearing before the judge. So when he actually gets the case file, it's already done. That's the bingo, isn't it? I mean, or is that totally a breach of trust?
I'm not following you there. Is that a breach of trust or what now?
Oh, well, okay. If I basically got the file from the clerk before the court was in session, say I have a court date in August sometime, anytime in the month of July, I can go into the courthouse, get the original, I can negotiate that instrument, turn it into a non-negotiable instrument, and give the clerk back the file. And then when the court case
That's not going to work because you have no records of any kind of proof what you're doing.
Right, so that's just so it's sort of like a breach of trust.
No, that wouldn't be a breach of trust. Have you got a trust form first? Hello? Hello? We lost him. Okay, press *6, *1. Anybody to get into the queue line? We've got an empty board, so *6, *1. Raise your hand. Get in the queue line. Anybody got a question? *6, *1. Anonymous, you're up.
Well, hi, CW. This is Rick, California. And
Hi, Rick.
How you doing? I ordered my Gilbert book. It's on its way, so hopefully I'll have it Monday. In the meantime, since there's not anybody holding with questions, would you mind kind of briefing what it means to merge titles again and define, the two titles again? I took notes, but I just kind of want to, hear it again from you and just kind of get a little deeper understanding, if possible, about the merging of titles.
Okay. So the offer that they're sending you is the debt title. And
I'm sorry? There's a debt title?
That's a debt title, yeah.
Right,
that's the legal title.
Right, that's 9/10 encumbrance?
Yes, that's the 9/10 possessory title or legal title.
And then the equity title is 1/10, and that's the true title or ownership part.
In the beneficiary, or also known as the beneficial title or beneficial interest.
Beneficial title, beneficial interest, okay.
Also called the equitable title sometimes too.
Yeah, equitable title, right. All right, so in order to merge those, are you A4Ving them at all?
Nope.
The note at all?
Nope. No. We don't do an except for value. That's debtor creditor. That's general. That's not special. That's not private.
Okay.
That's public.
Okay. Just want to make sure I'm hearing you correct.
Yeah, that's a lot of people understand, because we thought we were operating doing except for value, and we're doing, the private stuff. And I come to study trust and find out it's not. The only way to get into private is through trust. If you're not doing trust, you're not doing private at all.
Okay.
So anyway.
And that's because trust law, the idea, definition of trust is it is private. I mean, that's the whole point of trust.
Yeah, it's equitable. Equitable is something that they've hidden for a reason, because they put the equity in trust.
Okay, so if someone was looking to merge their equitable title with their legal title, how would one, look to do that exactly? I mean, because there's a promissory note on this hypothetical person, and that promissory note has a deed of trust, and so my understanding is we need to merge those two.
First, you got to claim them to be yours to do something with them, and that's first step.
So if somebody wanted to claim, what does that person look to?
Because we use the moving titles platform to do anything we want with the titles. So first thing we're going to do is we're going to claim it. And there's where we do a UCC1 claiming that and a county recorder notice. So now I've got two witnesses to witness the claiming of the record or the record of the title.
Okay, so this person would want to do a UCC1, as we've talked about, and then when they do the UCC1, do they do a notary at the same time? Because the notary doesn't have a notary put public, or do they just create a document separate from the UCC1 and get signed, or does the two witnesses sign the UCC1 somewhere?
Okay, what are you doing with the notary?
Well, I didn't know if you need to notarize the witnesses at all, or myself. I mean, I didn't know, this hypothetical person. So if this person goes and creates a UCC1, where do the witnesses sign?
So there are no witnesses signing on there. They're just public notices. You're just making something known, the claim known into the public, and you're noticing the public that there's a claim.
Yeah, that's the UCC1 is the claim, correct?
Yes, yes, in the county.
But you said that, if I heard you correctly, I thought you said that the person creating the UCC1 would need 2 witnesses to verify.
The UCC is a notice witness, and the county recording of that notice in the county is your second notice.
Oh, I see. All right, so the UCC is 1 witness, and then the recording of the document is the second.
Yeah, now, I got to clarify what you said there, because it's not the recording of the document. It is the recording of a notice in the county.
Of a notice.
Because if you take your actual documentation and record them into the county, you just gave it all to them. Or if you attach it to and send it in on the UCC1, or put too much information in there on the collateral block, describing everything fully, you just gave it to them. You waived it. You waived your privateness. So we have to be very careful how we make out these UCCs in these counties, because they have to be strictly just enough information in there that you're just giving reference to something, say like an RA number, is being claimed and held in the private.
All right.
And this is just a notice of that.
All right, so in the UCC1, that's where the person would want to put, like I said, a registered mail number in there, and then that registered mail number would be connected to the notice.
The new reference to the title, yeah, the actual.
Now, when you use the word new reference to the title, would that person be creating a new deed of trust or a grant deed?
No, it's just a new number you're assigning to, say, the deed of trust. That is going to be a new RA number, and that represents the deed of trust. Except nobody knows that except me.
Yeah, but the number has to be attached to something. So I guess I'm trying to understand what that new deed of trust is going to look like.
I get a survey that I do, which becomes the title, and I
Right.
put all the details and stuff all in there.
Right.
Connecting it all, descriptions and all that stuff. But now I make another document that just gives notice to that other document I just created.
All right, so if I'm hearing correctly, there's actually probably 2 pages. First of all, the notice of the home.
Two separate
pages.
One is a notice, and it's making reference to that other document that it contains that I'm going to hold in the private, and nobody's going to see that one.
Right, and that's
Got all
particular.
the details on it. That's got all the details on it.
That particular private one, could you use when describing a home, if you're using the home for the example?
The legal description, the block, and the plat, and all that stuff, you know.
Yeah, that would be page 2, I think, or the addendum page to the original note. They usually have on your original note, they usually put an actual legal description, lot so-and-so, plot this.
Yeah, now if I could, I'd probably want to go back, get out of the torrent system, go back to the old meets and bounds and stuff. Describe it the old way.
Okay. All right. Where would someone find that type of description, or would you just have to learn how to describe it, like we're 100 yards from this street, or we're 5 yards from this street? How would you describe that, or is there a way to describe it a certain way?
Yeah, you probably have to go back to do a, kind of like what they were doing with the allodial title. You go back in the back records and find out where all that stuff is.
Okay. All right. So
if I have time, you do that because, you know, otherwise I would still use the title, because what we're going to do is, it doesn't make any too much difference. We're going to change the survey. We're going to identify it, its identity, which is its name, its boundary, and it's now public, and we're going to make it from public, we're going to go back making it private.
Okay, so then, all right, so then once you do that, does that have to be preceded before filing the UCC1? Do you have to precede that with any notices to the previous
yeah, you have to notify all the parties of what you're doing, yeah.
Okay.
So documentation has to be sent to them, yeah.
Okay. And 3-day notice is plenty for them to respond when you send it in?
I don't care whether they respond or not.
Okay, I thought since we're dealing with UCC, do you have to give them 3-day
no, we're not
notice?
Dealing with UCC. They're UCC forms. Well, as soon as you check that little block, it says non-UCC filing. It's not UCC.
Oh, I see. So you just check the non-UCC. Okay.
These are just notice filings. In fact, that's all UCC is anymore from the year 2000 and forward. It's just a notice filing.
Okay. All right. And so you just have to give them one notice or 2 notices to all parties?
Well, I give them the 2 witnesses, so that they've been given everything between it's privateness between the parties, So I give them full disclosure.
Well, I realize that, but I guess what I'm trying to understand is the procedure, the process of the procedure. You give them notice that you're going to file a UCC1. You have to give them notice that you're going to do that. But then you mentioned 2.
No, I'm not giving them notice that I'm going to do it. I'm giving them notice that I did it.
Oh, okay. Well, that's what I was asking. So you go ahead and do the UCC, the 2 documents, and get that done, filed, and recorded. Then you send them out a notice saying that this has been executed.
Yes, right.
Okay. And that's it. And you're done. And you just have to wait and see what they're going to do.
Yeah, but there's other steps involved. You've claimed it. Now you got to do something with it. It's yours. You got the right to use it. So now you got to move. Now you got to move it.
All right. So then now you got to move it. Okay.
So now it depends whether or not you have a previously established general deposit that you need to withdraw first, which you're going to withdraw it on a UCC3 in another county, withdrawing it. So those are 2 records that you withdrew it. Then after you withdrew it, you're going to do another UCC3, redepositing it back under special this time. But that's only if you have a previously deposited general deposit.
Okay. I'm sorry. The language gets confusing a little bit. Okay. Now you have to.
If you don't have a general deposit already, and you're going to be doing it for the first time, then all you need is a UCC3 that you would be forming a special deposit with. So you're using that as a notice that you formed it. So you're creating a trust on this. So it depends what you have going on. If you have a general deposit, you got to withdraw it. That involves another UCC3 to withdraw it. If you don't have to withdraw because you don't have anything formed, then all you need is one UCC3 as a special deposit and notice. That may be a little bit confusing, but
yeah, it is. I mean, I'm really working hard to listen to it. All right, so because I understand general deposit is in the public, special deposit is in the private.
Yes.
All right, so when I create the UCC3, because I've never done deposit that I'm aware of, so so I'm going to create this person.
Well, you're talking about a mortgage, right?
I'm sorry. Yes, we're talking about mortgage. Yes.
All right, you've already made a general deposit. Now you need to withdraw it.
What was the general deposit? Was that the original note that I signed?
Yes. Anything that you sign today and you give to somebody, I don't care who you give it to, the person you give it to is a depository.
All right, so my original note
deposit. You just made a deposit, no matter whatever it is.
All right, so my original note was a deposit.
Yes, yes, it was a general deposit by default, which gave rise to the debit-credit relationship.
Okay.
You never knew it.
Right.
So now you got a general deposit that you need to correct. You need to correct it by withdrawing it out of general deposit and redepositing it back in as special now. So you're changing the nature and character of that general deposit, and you're making it special by a withdrawal.
I'm just writing this down. All right, so now I have to create a special deposit. And the person would create a special deposit by creating a UCC3 addendum.
Now that's just a notice. That's not the actual formation of anything. That's just a notice of something that I've already done.
All right, the UCC3, it is the addendum, right?
Yeah, that's the addendum.
All right.
Yeah.
That's a notice.
Of some past event.
Notice.
And that would be, you've already did a delivery or a redeposit, or you've done a withdrawal, one of the two.
All right, so that UCC3 will state something to the effect that, I would put in there something to the effect that I'm withdrawing the original deposit of this $518,000 note.
Nope. Oh, no details, no details.
All right.
You've got a new title with an RA number, and you make reference to the RA number.
All right, so I'm withdrawing. Okay, I'm withdrawing the funds of my original note and applying it to the RA number or registered mail number of XYZ, whatever that is. Am I thinking incorrect here still, or?
Yeah, you're just going to say basically then that this is constructive notice of a withdrawal of RA such and such a number from general deposit. That's basically what it is.
All right, this is constructive notice of withdrawal of RA number so-and-so, whatever, fill in the blank. And that goes on the UCC, huh?
Yeah, now probably want to make a little bit of difference, reference to rights and right title and interest is being withdrawn.
Rights, title, and
in reference to it's a mistake. It's mistaken.
Because of a mistake?
Yes, mistake.
Okay, now, if I go into the Skype and get a little more detailing, or can we talk a little in more detail?
And for a reference.
I'm sorry?
I believe she just sent you a reference for the deposit.
Oh, okay. I see the welcome to the Christian Walters group, so I just need to accept that, I guess. Yeah, she's got me in there. So I'll look for that link to whatever. I don't see the link yet, but okay. Well, this gives me a lot. I mean, I've just been downloading. I've got Gilbert's coming, and you know, this tomorrow and Monday are going to be.
What's your Skype handle?
It's rick.g8. I just.
Can you give it again one more time?
I just Skyped her.
All right. Okay.
She's got a Skype. I just Skyped Faith to Trust. Can I ask another question?
Yeah, go ahead.
A little different. I don't want. If nobody else is waiting, I'll just ask this. I had sent a debt validation letter. You know, I've got a first and a second. My second was a home equity line. To give you a little background, and this party's home equity line obviously HELOC. So I sent a debt validation letter was sent on behalf of this person, and just to give you a little more story, this person's had the originally was Countrywide, then B of A took over, and B of A got rid of it and sent it to Greentree. Debt validation letters, my understanding, has been sent to all parties, servicers, beneficiary, trustees, everybody, and so forth. Today, this party received a letter back from the corporate legal department of Greentree, which is supposedly the current servicer. And it was interesting that because this party filed a BK in order to stop processing and so forth of the foreclosure last year. My understanding is the BK was completed or discharged in November. But it's interesting that the letter I saw today says that the notary so-and-so requested that we treat this correspondence as a qualified written request. Please note that the purpose of a qualified written request is to receive information, clarification, or corrective action regarding problems and disputes with the servicing of a loan secured by a first lien mortgage. You're requesting information for a home equity line of credit. Therefore, this loan is not subject to 12 U.S.C. .2605, which is in Title 12, obviously, and fiduciary duties. Notwithstanding, you have not remitted any payments to Greentree. Accordingly, we are unable to furnish you with payment history. Greentree does not escrow for any items associated with your account and has not assessed any fees in your account. Now, what's interesting is they footnote a couple things. And the first footnote is that they're saying that the BK was discharged in September 09, and it wasn't discharged till November 09. So, but it also says in the footnote, and this is what's confusing, although you are now no longer obligated to pay the debt, the lien securing the loan survived. Now, being that it's home equity, my understanding is home equities operate similar to credit card debt, although the difference being that they usually have a lien associated with it. How would you advise this person to go forth to making sure that, it says here in writing, no longer obligated to pay the debt, but the lien securing the loan has survived? What would the person want to do in that situation?
Well, does the bankruptcy discharge the whole thing?
Well, that's what it looks like they're saying. That wasn't my understanding from this person, but based on their letters, based on their letter that was just received today by this person, it appears that they're claiming that the person is no longer obligated to pay the debt, quote unquote, and that the lien securing the loan survives. I don't know how a lien can survive if there's no debt, if you're not required to pay the debt.
Right. Sounds like how could the lien survive in a bankruptcy?
Yeah, I mean, if the person's no longer obligated to pay the debt, comma, the lien
sounds like a trick to me.
That's what it sounds to me. And just previously to that, in just in case somebody else is listening to this,
I tell them, hey, how can the lien survive a bankruptcy? You know.
No, yeah. Well, they bought it after the BK, is my understanding.
I don't care whether they bought it after the bankruptcy. That would be great if they bought it after the bankruptcy. You bought a pig in a poke, guy.
Yeah. And so my understanding, I would think this person.
I would give them notice that you got the bankruptcy papers. I'd give them the final discharge of the bankruptcy and tell them go fly a kite. Tell them, call me again. I'm going to sue you. Breach of.
Well, I actually. The person actually, gave them a debt validation letter, and so they're responding to that. But I just if you give me a couple seconds here or a minute, I'd like to read some because it might be of interest to other people. On the letterhead here, on the letter, it says.
Debt validation for what purpose?
Well, the idea was to slow down the person wanted to slow down the sale date of the house and force them to come up with documents. They, being the second, it's not really technically foreclosing. It's the first is foreclosing, but that person was advised to go ahead and send the debt val to both the first and the second, even though the second wasn't doing the foreclosing. And so the only responses this person's been getting has been from the second. The first people in the first really haven't been responding. But
how long of a response time did you give them?
The response time the person gave was 3 days plus 3 days mailing, which UCC requires since we were dealing on
Has that been certified as being a default now?
Oh, yeah, they're way out of default because it was sent out the 17th of June, and the letter was just sent out on the 14th of July. And so, I mean, even if you do a 21-day UCC, 21 days, they missed that deadline. But UCC, my understanding is...
Any kind of notary certificate of a dishonor of any type, any certification of any dishonor, is automatic grounds for an estoppel, res judicata, and the doctrine of unclean hands.
Yeah, they didn't even send the document back to the notary. They sent it directly to the party. So that they're in violation because the debt val letter clearly says all responses are to be sent directly to the notary.
Yeah, but most people don't know what to do with that, what they got.
Yeah. So they defaulted on that, and then I've also had the parties also sent a second follow-up letter letting them know. But now this party's got this, but it says Green Tree Servicing, the servicer for your above reference loan, received correspondence.
If you have a notary certificate, you have grounds for a temporary or some kind of enjoining action, whether it be temporary restraining order or preliminary injunction.
Oh, I have that.
That is an equitable grounds right there.
I got two.
Irreparably harmed and damaged.
Yeah, the party has two. The party has one sending the first letter out on June 17th, and then the follow-up letter when there was non-response.
If there is any of action going on in court, that is also the means to get it thrown out of court, because he who comes into a court of equity must be doing equity. That notary certificate, you don't know how powerful that is.
Okay.
With that, and that alone, you can get a court case thrown out of court.
Well, I'll keep that in mind because right now, there's the parties filed a federal lawsuit, and we're waiting on the first against the first trustee deed and the holder of the first trustee, and that was filed and delivered on the 14th of July, and sale date's the 26th of July. So we're hoping that the party's hoping to hear something from next week to say that the sale date's been canceled, at least, or postponed. So we're looking for that because we've got.
Well, I would come in with a counterclaim, or if that thing, you get it back open, jam a counterclaim in there and use that as the unclean hands doctrine and use that as an estoppel to reverse it all. Cancel the sale on it or something.
The first hasn't responded at all to the debt val letter. They haven't responded at all, from my understanding. So
nobody knows what to do with it when they don't.
Yeah, well, this is what they're saying here, if you don't mind. It says, from the documentation submitted to us.
What they say means nothing. It's what you're doing with your certificate that means everything.
Well, I haven't done anything with the certificate other than the party's got the certificate. The party has that ready to go. We've got two of them because there's been two letters served, and so it's just a matter of understanding how to.
I would use the certificate, the means for, after the default, that gives me authority to rescind the contract. Because I got to get them out of play first. And I'm going to use that as to rescind the contract because they never validated the debt. and that's certified. Then the second thing I'm going to do is I'm going to jam up the public side of the court with the unclean hands with an enjoining action, putting a stay or a temporary restraining order against it, stopping all actions, and then I'm going to get the whole thing reversed if it was going for sale, because equity says that they're entered into court with unclean hands, and now equity can't ask equity to be doing something that they should be doing themselves, and that cancels the foreclosure, the judgment. That's what I would use to vacate the judgment.
Okay, so I would file, or the person would file what? They would file the certificates under another certificate to the court?
Yeah, all this litigation stuff, this hasn't got nothing to do with NTT and trust.
No, I understand. All the party's trying to do is get the postponement of the sale date so that remedy can take place.
Yes, but you need to come in with your certificate as your SOI to your NOI claim, which would be unclean hands, and use that as a good cause shown as why a injunction should be issued.
Because they refused. I'm sorry?
Stopping the sale.
Stopping the sale, right. Okay.
And then go back in and open the case up, either sue the case or go back in because you can open it up because the time hasn't gone by, but it might have. But anyway, I've come in with a new counterclaim or claim, get that thing back reversed.
Would,
now, the equity principle that they had unclean hands and they asked equity to do their foreclosure, which they had no right to do because they themselves were not doing equity.
Okay. Do I need to do a non-proton type situation, or?
Yeah, it goes all the way back because equity will reverse it all the way back when they filed the case.
When they filed the foreclosure back in March of '09?
Yes, it'll reverse it all the way back.
So do a non-proton, just have a notary then notarize currently, of course, and do a non-proton and have them notarize that. Because we're just now coming, non-proton, you use that basically, my understanding is use that when you just learn information that's pertinent to the case that you weren't aware of before.
Yes, because the thing arose out of the case at the beginning because they didn't have a debt to begin with.
Right.
And we usually use the 9-210A4, which was 14-day debt validation, and when they don't do that, then that gives us the notary estoppel that sets up the res judicata, sets up the unclean hands doctrine, and we come in with the adjoining action, and all this stuff is just strictly litigation.
Yeah, the letter here that they're claiming, we know they're illegal, but this is the kind of the wording they're using. It's really amazing. He says, from the documentation submitted to us, it appears that you have been in contact with, quote, debt elimination.
I don't care what they say in those.
I understand. I know you don't, and neither do I. But I just think it's interesting that they even say it, because now they're saying I'm in contact with a debt elimination company. And they say they supply borrowers the package of documents with legal-sounding jargon. The documentation is, however, mostly incomprehensible, sets forth no valid or recognized legal theory for eliminating debt, and are wholly ineffective for the purpose for which you obtained or submitted them to Greentree. Several federal authorities have posted websites identifying these types of debt elimination scams and others, warning financial institutions and consumers to be on the lookout for them. As these documents have no meaning since you paid for them, Greentree is returning them to you. So they return everything that was sent to the party. It says, to ensure that there is no misunderstanding of Greentree's position regarding this correspondence, we respond to several of the claims made in the correspondence. And the first thing they respond to is the debt validation and notice the right to cancel. Enclosed is a copy of the home equity line agreement and disclosure, HELOC, you signed on the August of 2006. This is sufficient to validate the debt you once owed. And then it's footnoted, and it says in the footnote that Chapter 7 bankruptcy was discharged on September 4, 2009. Although you're no longer obligated to pay the debt, the lien securing the loan survived. And then it says, further, you opened this HELOC over 3 years ago. You have no right to cancel your loan. And then the second thing they're disputing is qualified written request. The notary requested that we treat the correspondence as a qualified written request. Please note that the purpose of the qualified written request is to receive information, clarification, I think I read that already. And then the third thing was Green Tree.
Certificate say?
The third thing was that Green Tree does not acknowledge the so-called fee schedule, because I included a fee schedule.
What does your certificate say? You're from the notary.
The notaries, yeah, I'll tell you exactly. It says that, where is the mortgage?
Yeah, that other stuff is just to get you to argue.
Oh, yeah, exactly.
Point and drag you. They're going to drag you back to their issue. No, I'm going to drag them back to my issue.
Right, exactly. Let's see here. I've got all.
I wrote the debt validation thing and asked them for the thing. It was written in such a way that they had 14 days to validate that debt, or else the validation stands as I owe you 0.
Right.
And they were in agreement with that. And then I'm going to pull them back to that, no matter what they say.
Right. Well, they're trying to argue that, in my opinion, what it sounds like, they're trying to argue that HELOC loan is different than a regular mortgage. And I would substantially agree with that in the sense that HELOC, my understanding anyway, is that it's more like it's a credit line and it's more like a credit card. And it comes under a different type of debt, although it is secured. Am I wrong in thinking that way?
Yeah, but they still have to validate the debt. If there's no validation of a debt with no kind of documentation, then and then we specify all the time specifically what we mean by validation of debt. We want you to swear under penalty and perjury as to the issue. If you can't swear to it under penalty and perjury, then there is no debt because you just made an agreement to lie.
Mm-hmm. So if you cannot swear under penalty of perjury.
And all my documents that I send in, I swore to them. And they're sending you back all this crap that's not sworn to. So.
Well, I sent an affidavit of notary presentment, certification of mailing, Cal Government Code 8205 duties on 17th day of June 2010 for the purpose of verification. I, the undersigned notary public, being commissioned in the county, state, noted above, do certify that Mr. So-and-so, so-and-so, on certificate of service. Number 2, qualified written request. Number 3, fee schedule. 4, notice of revocation of power of attorney. 5, notice of right to removal and exhibit. Number 6, notice of right to cancel and addendum. I, the below signed notary, personally verified that these documents were placed in an envelope and sealed by me. They were sent by United States Post addressed to, and then all the respondents, which would be Countrywide, BAC Home Loan Servicing, Recon Trust, Green Tree Servicing, and MERS, all 5. And notary signed and dated it. And that's my...
And you did a certification on non-response.
I haven't done a non-response yet. I can do that, but I haven't. I've got all the receipts that they received everything in a timely way. This is the first letter that was received by Green Tree, who happens to be the second servicing, the second mortgage servicing company. So that's. So you think that affidavit of presentment by the notary is everything I need, basically?
Yeah, all I need is some certificate issued by a notary of some dishonor that they do, and that creates the unclean hands doctrine. And people don't understand how powerful that unclean hands doctrine is because it's an equitable an estoppel.
Okay. Now, I don't need to quote the unclean hands doctrine, do I? Or I can say that, but I don't have to quote like the law or anything like that.
Okay, unclean hands doctrine is the statute equivalent of the equitable one that says, he who is requiring equity must be doing equity.
Mm-hmm.
So that's the maxim that I would be using.
He who
seeks equity must be doing equity.
Seeking equity must be doing equity.
It's like you come into court here, this is an equitable foreclosure, because they all say this is a mortgage foreclosure. What they really mean, and this is being foreclosed in equity, because equity gives them the power through equity to foreclose on your house. So they're in a court of equity, and they're asking a court of equity to do this foreclosure, but then they're coming in, they didn't validate the debt, and the notary certified that they're not doing equity. So there's a conflict of interest here, and equity will not allow that to happen, but only if you make that claim.
Okay, so I've got to make the claim.
Yeah.
And
so that's how that is, really, and most people don't understand that.
So I'm going to respond to this letter, and basically I'm going to remind, first of all, do I need to correct them on the discharge date of my the bankruptcy? So it'll be in September,
this
I know.
House has been foreclosed on already, right? It's already being scheduled for sale, right?
The foreclosure was in March 2009. It got stopped because of BK last year, and they started the sale date this year. In June, we got a notice for July 7th sale date. I got it postponed till the 12th, and we got it postponed till the 26th of July. So that's kind of where I'm at. But it's not the second that's doing it. It's the first.
Well, the notary certificate would be the equitable estoppel that I could use. That would be the grounds for the show cause as to why I should not have an injunction to stop this from being irreparable harm.
Yeah.
Because they never validated the debt and they're violating equity. Then I would come back and attack the case that was the judgment on the case.
Mm-hmm.
And I would use the very same thing.
Okay, so then, since the second is really not foreclosing, but they did respond, I still should respond to the second.
Okay, this is another case you're talking about? Somebody else, another house?
No, this is the same house. There's a first and a second mortgage. The second is the one that sent the letter, the big letter saying all this stuff about being a HELOC versus a regular mortgage. The one we've been talking about, the same one we've been talking about. Nothing's changed. I'm just saying that the second is not foreclosing. It's the first that's foreclosing.
The first is for mortgages foreclosing.
Yeah, they're not, but they haven't responded to anything. And they had the same letter sent to them as the second.
What was the first case on then? The first mortgage? Or the second mortgage?
The response that I received that I just was reading to you.
No, the mortgage foreclosure, the case itself.
The foreclosure case was for the first, not the second. It's for the first.
The first is coming back at you again? And after a bankruptcy?
The first, yeah, because it had a lien on it. They at the end of the BK, they sent a letter in December saying that they were petitioning the court to take it out and to proceed with the foreclosure. But see, I didn't know any of this stuff at that time. Have I known all the stuff that I know now, I've only just learned in the last 60 days or less, my understanding was I could have, while I was in BK court, I could have forced them to show documents and show cause and show standing.
Right.
We probably could have wiped this out in BK.
Right.
But I didn't know any of this stuff then. My attorney obviously didn't know it. so the letter...
They work for the court.
I'm sorry, you broke up. What?
Attorneys don't work for you. They work for the court.
Yeah, well, that's what I found out in the last 60 days. Their bond is controlled by the government. So, yeah.
They get paid from both directions.
Yep, they sure do. And they double in the deals. So, I guess the bottom line...
In the bankruptcy discharged the first mortgage, right?
No, they didn't because it had a lien on it.
Oh, maybe that's my misconception then, because I thought the bankruptcy, you got the thing discharged from the bankruptcy.
No, the second lender that that sent the letter, the one I'm reading for, the second lender said that on May 22nd, you filed Chapter 7 BK, which was discharged, et cetera, in September, which is incorrect. It was November. Although you are no longer obligated to pay the debt, the lien securing the loan survived. My understanding is on a HELOC loan, because it's like a credit card, it works the same as a credit card, that the second mortgage can be discharged in a BK7, where a first mortgage can't be.
Let's back up. What happened in the bankruptcy? What happened in bankruptcy?
Everything we got discharged. All of our debt got discharged. All of our unsecured debt got discharged. And it appears, based on what I'm reading here, that the second mortgage got discharged also. But it's saying that the lien securing the loan survived. And I don't understand how that could be.
So this party went bankrupt. The bankruptcy court discharged all their debt, but yet this company's coming back at you and trying to get you for the lien, which was discharged in the bankruptcy.
The first was not discharged. The first mortgage was not discharged. They're the one foreclosing. The second appears to have been discharged based on the information that I'm receiving here on this letter. And I'm going to call my attorney on Monday to confirm what they're saying here. Because what they're saying on the second mortgage is that although you are no longer obligated to pay the debt, the lien securing the loan survived. And that was my question. How can they have a lien survive if there's no debt? There's a lien on the first. That debt survived because it's a first position regular mortgage. But a HELOC loan is like a credit card, is my understanding. That's the way it was explained to me. And so it comes under different financial rules. And therefore, you can wipe out a second, or a HELOC loan can be wiped out in a BK where a regular mortgage cannot. At least that's the way it was explained to me.
Well, something is not right. Something's screwed up there.
Yeah, I'll have to call my attorney on Monday to get confirmation of all this, but the letter just came in this afternoon, so I wanted to throw it out to you since there was nobody waiting for a question, so I thought I'd ask. But I'll let you go if there's anybody else waiting. I appreciate you taking the time and really, hammering that out for me, and I appreciate that very much.
Okay, all right.
I'll see you on the welcome NTT group too. Thanks.
All right. 718, you're unmuted.
You there, Christian?
Yeah. Hi, Harold.
How you doing? Oh, wow, I wish I could have got on when the other guy was on. He said that HELOC was in the second position, correct?
I believe so.
Okay, if it was in second position, first position basically takes over. And the second would be out in the cold. There would be nothing for them to collect on that lien because of the first. So that second would be essentially just extinguished, and the alleged debt has already been extinguished. So there's nothing for them to collect.
Yeah.
Okay.
Sounds like it again.
Yeah, for the people that are, contemplating bankruptcy, and they want to get everything discharged, what's been sort of like a little movement going on is that they would declare everything on the Schedule F as unsecured non-priority. Everything, house, note, everything. And then when they object, stating that they're a secure party and they want to lift the stay, that's when you bang them with all the, the popular arguments out there now to make them prove up the claim to show that they're the creditor, et cetera, et cetera. And there's an attorney in Florida. He's sort of like a rebel, and he's kicking butt doing that way, getting houses, the notes discharged, and the people are getting their houses free and clear. And then there's a movement out in California. They're doing it out there too. So that's something for people to consider. Again, do your own due diligence to make sure you're doing everything correctly. But it sounds like a viable option, to force them to prove their secure party status rather than just automatically granted them that position via the forms.
Yeah. I wish I had known that one before.
Yeah. Me too, because there's some people that really could have used it.
Yeah.
That I've dealt with in the past, but that's
sort of being honest. Come in and said, hey, prove up the claim instead of list it as unsecured. Yeah.
So on the Schedule F, list everything as unsecured, non-priority, and then they have to prove up the claim, which we know in most cases, well, in all cases, they can't. And last week, there's a lawyer down in Florida had 5 cases resolved last week. So it's definitely working. So that's for the people in the future. And then within that 7-year span, another thing that I just recently learned was that, and this information came to a young lady that was in bankruptcy, and she had a judge that was very, very friendly and very educational, and spent quite a bit of time with her in the courtroom, telling her what she needed to do.
Wow.
During the 7-year period of a 7, you can reopen and add other things in there to be discharged. I didn't know that. You can continually reopen the case to get things discharged. And when you look at it based on the true intent of HR 192, that only makes sense.
Yeah.
So once you get that case open on 7, they discharge everything. That case basically remains open for 7 years. Or you can.
Well, if he had a bankruptcy prior, then he could go back in and open it up and possibly. Well, let's see. He already had it in there, so relist that case for that second. If it keeps on coming at him.
Well, he'd already probably did the schedules in that case already, unless he goes back and amend them. But more than likely, based on the formation of the forms, they set up creditor and debtor, and by the time when you sign those documents, you basically admit to creditor and debtor.
Yeah.
So, what some people are also doing is they're as an addendum to the documents, have either a notice or an affidavit notice declaring your position with regards to debtor. You would be alleged debtor, and creditor would be alleged creditor, and creditors will not be creditors until they prove it. And also with the B-10, just don't rely on the B-10 form by itself. But the statutes allow you to request over and beyond to force them to prove up the claim. So hopefully that can be helpful to some people that are operating in BK, for temporary measures or for actual relief. Now, this is something I heard recently with regards to trust in the BK. Because we all know that the BK whole thing is, based on trust. Debtor, creditors, just the guys for what they're actually going on. Go in there, declare the trust. especially on the mortgage. This is based on the mortgage, or you probably can use it on the credit card also. Give the judge an order to sign for the trustee to go and trace down all the assets off of the note from fractionalization and securitization, bring it all back to the table, pay off whatever is allegedly owed after proving up their claim, pay the trustee and pay the court, and there should be money on the table. I said, wow, that sounds pretty creative.
Yeah, works pretty good.
and that's trust, using trust in the bankruptcy. And they gave you a clear sign that it's all about trust because they got a trustee right there. So there's some things to think about. And I wish I had got in on the other call. We were dealing with the guy with the appeal of the traffic thing, because there's a few procedural things that and I wasn't taking notes because I was multitasking while I was listening. But there's a few things he needed to know also, procedural-wise, on that appeal. But
that was Floyd. Yeah, so we can talk to him later.
Okay, that's all for now.
All right. Thanks, Floyd. Excuse me, Harold.
Okay. All right.
805, you're unmuted.
Oh, great. Thanks for taking my call again. I got cut off earlier.
Yeah. Yes, we're just starting to get into it. Forget what it was now.
Oh, yes. You're such a trooper. Basically, I was talking about the instrument and the non-negotiable instrument, and if I could just elucidate a little bit more. I was from the UCC filings, essentially, there's a notice, and I've been doing it. I probably really started listening to NTT, was doing a lot of the debtor-creditor, and I've already followed through with a lot of the basically conditional acceptance type stuff, and now I'm just trying to transfer it. So I'm thinking, okay, I'll make my addendum, my UCC addendum, withdrawing it from general deposit, and then making a UCC filing, giving them notice of special deposit. And on the UCC3, do you assign the trustee at that point? Do you do an addendum and an assignment? And
Forming of the trust?
Yeah.
Okay, now, we don't do a formation of the trust by an assignment of a trustee. We give delivery to the trustee, trust res. And then we give notice that we did that on a UCC1 in the county. So the county notices in the UCC are just notices of a past event. That was the delivery of trust res to the trustee. That was the formation of the trust. That's when the trustee actually became a trustee, when he was delivered trust res. And I have green tickets, green receipts, that the green card say that prove that he received trust res, which was my signature on documents. Are we still there? Oh, we lost him again. Dan, you're unmuted.
Hey, sorry about that. My 1-year-old in the back just found her lungs. Anyways, I got a question for you, Christian. I'm very new to Skype. How can I tell when I get an invite on Skype? What will it say?
It gives you like a little block. It says accept this party or something, and then you click on the block accept, and then that sets up the link, and then you don't have to do that again.
Okay, very good. And by RA number, when we were talking earlier about the title I made for my Tundra, the RA number you're talking, I just wanted to clarify, you are talking about a registered mail number, correct?
Right. Mm-hmm.
Okay, good. Now, I've heard you talk about in the past, on your past recordings, these Section 1, or Tim Turner's documents. When you go through and you do those, you're going to have to go back and undo them. I have only done the Section 1 documents, basically breaking the presumptions that I am a person, a corporation, a United States citizen. I've only filed at my county level. I have not sent off any bonds. Is there anything that I'm going to have to go back and redo on that?
Well, as long as you didn't create any negotiable debt instruments like those bonds or offsets, and if you didn't create any of those, then you don't have to reverse them. So it's like you're creating yourself more work to do under trust to get rid of it, so why create it anyway in the first place?
Yeah, I didn't like the idea of giving them more ammo, more money to be able to oppress us further with in the first place.
Yeah, we're creating debt to apply against as payment for this other debt that we owe, and then we're compounding debt, and welcome to the national debt.
Exactly. All right. Once I finally get an invitation, is that going to be able to give me access to previous audios, since I haven't been able to find any further than when you separated from Desert and his radio station?
Yeah, there's others out there floating around, yes.
All right, very good. Okay, so obviously the accepted for value is you said earlier tonight that the accepted for value is no good.
Yeah, it's out anymore. You know, coming from that realm, it was great when we knew about it, but now that I see from different eyes, through trust eyes, through NTT, it's working cross purposes, and it's not really extinguishing debt. It's mounting debt up, which we didn't realize that. And most everyone doesn't realize that.
Okay, all right. So I will start at 11.7 then and come forward. I'll quit wasting my time with the past audios.
I don't go back to the older stuff past earlier than 11.7, because that was debtor creditor. When we came to the announcement of the debut of NTT, which was 11.7 and forward.
Okay, done. Consider that done. All right, my last two questions are the biggest ones. I have these written down so I can go through them fast. Number one, sir, I am in the military. Since I have woken up, I realized that talk about being in the heart of the beast, I'm right there. I'm stuck in it all. Obviously, the contract that I signed has to be some sort of a trust. Do you foresee any way that I can express this trust and release myself, or as the military puts it, discharge myself early?
Yeah, why did it say discharge on there?
Exactly. Okay, what road?
The basic premise of NTT is to take everything, merge it, and that extinguishes it. And that's what I would be doing that on an individual, case-by-case, trust-by-trust, sub-trust, or whatever.
Very good. All right. And then my last question, I was obviously stuck before in the debtor-creditor system, but obviously it goes deeper than that with the trusts. I started validating my debt with Wells Fargo on my mortgage. I sent them a letter asking them for an appointment to come and visualize my original winning signature promissory note / contract that I have with Wells Fargo, whom is not named anywhere in the mortgage papers that I have filed. However, since then I have learned it does not matter who has the promissory note, since basically it was a negotiable instrument that I signed over to somebody else. Once they stamped it, paid the order of, that released my liabilities and placed it upon them, so it doesn't matter who has the negotiable instrument. I have since then tendered them a negative averment to Tim Turner. The negative averment started its 21-day cure on the 14th. I know that there's something else that I need to do that is way more powerful than a negative averment that has to do with trusts, but I don't know where to start. What do you suggest?
Have you done a debt validation with them?
Yes, sir. As per Title 15, Chapter 41, Section 1692, the Fair Debt Collection Act, it states in there that a debtor does not have to continue to pay the creditor until the creditor validates the debt with the debtor, which was what my first letter was based upon.
And do you have a notary certificate for that?
No, I have come to, since I've been listening to you, I have come to find out that anything you do, almost anything you do, you need to do by the notary, otherwise it's a he said, she said.
Yeah, right. So I like using that debt validation under 9-210A4 because that's something that's colorable on their realm that they can see. And I can use that as a tool to jam up the public side of the court. So I like using that simultaneously with the NTT and emerging titles on the private side. And that way I've got something going on both sides of the court, public and private, and I'm in control of both sides simultaneously.
Right. Okay.
So with, you know, if you got a debt validation certification by the notary, then that's the public side. And then I get something going on the private side now for creating the trust. And this is a mortgage, right?
Yeah, this is a mortgage, exactly.
Then it comes back down to where, you know, the first placement of the signature goes on that, which would be the mortgage application. That and the note. So
Right.
those two things, I would be turning those things into special deposit and formation of a trust, and I'd be backing out the withdrawal of the general deposits that have already been made, since it's already been done. I'm going to withdraw it and redeposit it, forming the trust and using it as the equitable asset to merge with the debt titles and extinguishment of the debt.
Okay, I'm not going to lie. I'm not even going to pretend to understand that I knew everything that you just said. However, I will, once I get accepted into your group, I will come back and I'll listen to this call again and start at 11:07, come forward and educate myself to understand what you just said. However, I do know that you just given me the tools that I need. I do have the copy of the letter, and I did send it by certified mail, the debt validation letter. I have proof of it being sent and it being accepted, and I have proof of what Wells Fargo sent back to me. I should be able to take that down and at least get that. I can at least register both of those items with a notary, right?
Yeah, are you in a mortgage foreclosure now?
No, I'm in honor right now. In fact, but at the 15th of this month, they will be starting to wonder where my payment is at. But I do have that prior letter in and the negative averment with them right now.
Well, you're sitting good then, because if you don't have any actions in the court, it'll take a while before that even comes about. So you've got enough time to study this, get up to speed, get up documentation ready, and by then we'll even be further along on what we know ourselves. So.
Fantastic. That's what I need to know. All right. I'll be looking for your invitation. Once again, it's Freeman, one word, F-R-E-E-M-A-N, space, Dan, capital F, capital D. All right, my friend. I will let you go on to others. Thank you.
Thanks, Dan. 561, you're unmuted.
Hey, Christian. Good to hear you. Glad to be here.
How are you?
Good. Well, not so good. But what was the number of the book on trust that we were in tonight?
When we were in tonight, that was Corpus Juris Secundum, book 90.
Right. Okay, book 90. That was my email. Okay. And I wonder if Harold was there, had the name or phone number of that attorney in Florida that could was winning the foreclosures for people.
I don't know. I'll ask him.
Yeah. And other than that, I'll give you a call tomorrow.
Okay. Anything else?
I'll probably talk to you tomorrow if we can get Harold back on there with any location or case number, or if he doesn't have a name or phone number.
I'll ask him and see what if he's got him or not.
Yeah.
Okay.
Thanks for everything. Almighty bless, keep and protect.
All right, thanks, Frank. Anonymous, you're unmuted. Hello, Anonymous.
Oh, hi. Again, this is Rick in California. I think Dan mentioned that he's in California. I don't know if he's in Southern Cal, but if he is, once he gets on the welcome group, I just want to put a shout out. Be happy to chat with him and try to learn with him or help in any way I can. I'm in the SoCal area, so if Dan, Freedom Dan is listening, when he gets on the welcome to NTT, he can check me out. The other thing is I was interested to hear the BK talk. Did I hear correctly that there's a potential, even though my BK has been discharged, that I can reopen it?
Yeah, that's what he said, yeah, up to 7 years.
Okay.
And add other things in there.
Because if I can reopen it, then I could reopen it and then change, I guess, find out if I can change the first mortgage lender to a non-secured debt and force them to come back through the BK court to prove that they have a valid claim. I mean, if I'm understanding what I heard correctly.
Sounds like a possibility, yes.
Okay. Just wanted to make sure I heard that, and I appreciate it. All right. Thank you so much, and again, I'll hang on until you're all done. Thanks.
All right. Carlos, you're unmuted.
Hey, good evening, everybody.
Hi.
Yeah, Christian? Hi.
Yeah.
Good. Going back to this gentleman about trying to go back in there in bankruptcy, most likely if he does a mortgage examination and foreclosure examination, there's someone out there doing it for very decent price, for $195, and he has some credentials. Now that'll give him a good standing to come back and open that case again. Because in bankruptcy, we have protection for 7 years in bankruptcy, right? And also, I wanted to add something to what Harold said, which is, I think, is right on track. Well, we have a lot of faith in Harold. Everything that he said, I've been doing myself, and it's been proven to be good, thank God. And I wanted to add that when anybody does exactly what he said and what I've been doing, and I think you've also been doing, saying whoever wants to do it, that's how we would do it, right? We don't tell them to do it, but that's what we would do. Whenever you place any creditors, you place all of them, even whoever owns, everybody, to make a long story short, right? Everybody put him on the unsecured, non-priority side, and guess what? Some trustees are going to tell you to say this is wrong and don't change it. I went through that. I went through my 341 meeting on July 7th, and the trustee says, did you fill out one of these documents? And I says, I am his translator. He says, you're not allowed in there. You're not allowed to speak. So I had to drag this guy out and I had to give him a crash course in how I would answer a 341 meeting. He did real good, but do not change. If the trustee tells you to go ahead and change those schedules, he's going to tell you to change from B to C, and this other schedule is wrong. Don't change it. He's not an attorney. He's an attorney, but he cannot do anything. He cannot tell you what to do.
I know.
And I did not change it. And I told him, you go back in there, tell them you and your wife reviewed it, and according to you guys, it's fine, and they're good enough. But he told him to change it, and that trustee knows better. He knows better. So I says, he doesn't have the right to tell you, and you're not going to change it. Well, he said, well, you listen to me. If I don't change it, it's up to you if you want to change it. He says, no, I want to do what you tell me. I'm not going to tell you anything, but I'm telling you that I will not do whatever he tells me. I'm going to do whatever I think is right. And
you made out some documents that put you in a trust, but if you made the documents out, you're grantor, and he's trustee.
Right.
You're grantor. You're the one giving calling the shots, not the trustee.
Right. So he's got no right, but they want to pretend. They want to make you believe that they have the right to tell you that.
Yeah, if they can get you to change your intent, you've lost.
Because if you come in there, like
you are as a mentor.
Yeah, if anybody comes in there and places their creditors where they tell you to place.
This guy, whose signature is on this document?
I know exactly. I know exactly what you mean. But let me tell you something. What I think.
Mentor, you trustee. You take orders from me, not me the other way around.
Right. But check this out, Christian. If you do what he says, you're admitting they are the creditors. If you place them,
worse than that, you're admitting you're the slave.
Yeah, that's even worse. Yeah. Anyway, I just want to make a little point, but my respect to Harold. We all love him. He's a great guy. He's a genius. But I guess he forgot to bring that point up. But good. That's what we're all are in here to throw what we think is good. Now I have my question. I have a crazy question, real crazy one. One of my brothers, he's very ill. He's got a heart condition, but that's beside the point. He has a note. When we did a validation, a qualified written request, they send him a note. It says, this is a certified copy of the original note. It says, great. And it's stamped, paid to the order of some other guy, some bank, right? Good. I'm going to take it and I'm going to record it. Since it is a certified copy of the original, and it says it's his, he has the right to record it. That's my question anyway. I think he has the right to record it, and then I can prove them that they have altered his trust rest. Am I right?
Yeah, they've probably changed and put markings on that and added
yes,
to it.
That's what I did. I mean, and then I have proof of what they. I mean, I have it's in public records. I don't think they can. I don't think they could deny him the right to record this. And it says paid to the order. It's paid off. It's without recourse. Why are they trying to foreclose? It's without recourse. If you look up recourse on the Black's Law, you'll find out. Anyway.
Did they swear to it on that certification, or did they just say that they certify?
My brother called me and I says, I want to see that tomorrow. This is in a package they send him, because I called him about an hour ago. He says, you know what? It's what kind of documents they have? I have two notes. One that they sent me in December. I have a new one. The one in December. It says verified copy or something, or original, verified original copy, and it's stamped.
Yeah, but see, unless they swear to it under penalty of perjury, then they can't validate that was the original to make a copy from.
So they lied, huh?
Yeah.
Yeah.
It
okay.
could be a copy of a copy.
Yeah, and you know who says hi? I saw him today, Greg Gentry.
Mm-hmm.
I met him today. He says, hey, say hi to Christian. We were talking a little bit about the whole business. Anyway, I says, I wrote this thing down. Now, I know someone.
You going to see him again here in the future?
Yeah, tomorrow.
Okay, well, tell him I'll see him in his seminar down here in Florida.
Okay, yeah. I went to his seminar today, and it's gonna be tomorrow there also. Okay. And now, also, I have, give me 1 second. I know someone, I was talking to another guy that believes in bankruptcy, for everybody who believes in bankruptcy and wants to try bankruptcy as a remedy before we get ready with NTT. He puts in there his property taxes, whatever he owes the IRS, he puts everything in there under the unsecured non-priority. And guess what? Nobody showed up. And he's suing whoever comes back. This goes back to the other gentleman that called about a few minutes ago, and he says that the second lien holder, right? The second lien holder is coming back. Just
right.
Connors him. Just Connors him. He has no right. I would Connors him for tort. That's what I would do. I mean, It's only fair. Okay, I guess that's all, Christian. I had it all written on, and I went through my list. Well, thank you, Christian.
Okay, thanks,
I just had to let it out. That's all. Thank you.
Hello. Hey.
Yes.
I've switched from AT&T to T-Mobile, and I guess it was a bad idea. Sorry about that. It seems like every time you take my call, I get cut off. Sorry. I apologize for the service. Anyways, okay. So, yeah. I guess my questions basically are pertaining from switching midstream from DC to trust in a case. That's essentially what I'm looking at doing. And I have filed a lot of the paperwork, and I kept asking about the non-negotiable instrument, essentially. And what I was getting to was, say you do all your NOI, you turn in all the documentation to show there's a trust, and then you go ahead and negotiate that and turn it into a non-negotiable instrument. I mean, would that resolve the controversy? Would that work?
Well, yeah, it would, but if you're doing this all on the private side, the public side has no idea what you're doing, so that's where the notices come in, and you have to give them some kind of enough that they can see that gets them in a position where they're going to recognize what you've done.
Yeah, that's kind of what I've been trying to get to. Basically, then the UCC filings are non-UCC filings are just the notice, and that's basically you make an addendum saying, okay, well, I'm taking this all out of general deposit. I'm giving you constructive notice that this is removed from general deposit, and include the RAs and potentially the court case too. Could you even, or would you not put the court case?
Yeah, you could. The court case itself is the trust, yeah.
Right. So you do that. You make an addendum, and then you do another UCC 3 filing saying this is for special deposit, and then include all that once again in box 4. And I was wondering if you did an assignment also, but you said no assignment.
Well, you know, the UCC 3s are assignments, but we don't use them as assignments. We just use them as notice that a transfer, which is an assignment, but a transfer took place, but the transfer took place on actual mail delivery on the greeting cards. Right. Because that happened in the past. Because as soon as I know that they got it, then I'm going to file the notices on the UCC 3s, but it's the notice is on a past event.
Yeah.
So the notices do not form the trust. It's the actual delivery of trust res.
All right.
Confirmed on the green cards that they got trust res.
Right. Now, do you have to file a counterclaim for this to actually to go through? Do you have to file the counterclaim? If you don't file a counterclaim and you do all the other process, would that be?
Court is a DIB hearing as a crossover mechanism to get in from the public side, come through the public side door, go through the first door, get into the public side court, and then go through the second door and get into equity, which is in chambers, so we can get our substantive rights, which is like the portal into the private, showing them what we've done in chambers.
Right.
And that's the only place they can see that.
So you have to file.
I bring that evidence. I can't bring it in the public side of the court because I waive it. So I got to have it in chambers. That's the only place it can be showed up at.
Right. So you have to file your counterclaim to do that, to get the DIB hearing?
You need some way to get into that because that's the way they've created it. And we're just using it to get into that second door in the court to get us into equity.
Okay. And a protective order, you don't think that would be sufficient? That's not sufficient enough? You have to also have the counterclaim?
Yeah, you got to have the counterclaim because that's an equitable action.
Got it. Okay. Makes sense. And that counterclaim, I mean, this is the thing. It is kind of like a rabbit hole. Say I got 30-page charging instrument that they brought to me. Now, if I go and rebut every assumption on that with my counterclaim, it's going to be a pretty big counterclaim. And also, you said, I think earlier in the call, that you don't ever put in the amounts. Like, you don't ask for the amounts in the counterclaim. Is that correct?
Yeah, because we're not really going after damages or anything. We're getting whatever the debt title is extinguished by the asset title.
Well, what if you wanted your disbursement? Say in a case where you had you basically had an asset of a business that's been dismounted, dissembled, or whatever, however you would say that.
Come in as a right, see, because you're talking about a value, and value is public. I'd come in under a right. I would come into a right to have a business.
Right.
And that was taken away from me. That right was taken away from me.
Right. Yes. So isn't there obviously is an amount associated with that right? And
I would come into, I want you to make me whole, and if you can't make me whole, then court, come up with some other idea, and they may suggest, okay, we're going to give you damages. Fine. But that was up to you. That was up to the court, not you.
Okay. But say they don't. I mean, since I'm making a counter suit.
Well, you see, the court of equity is going to have to make you whole.
Oh.
And they will probably give you an award of damages.
Okay. Unfortunately, I don't really have a lot of faith in the judicial system and the way these fine public servants operate. So it's hard to imagine in the private that they're going to be 100 degrees the other way. And they're going to really want to facilitate some.
We have a hard time looking at the system, and we tell them it's like we go over to France and we tell the French over there, hey, you guys are running your country all wrong over here. You need to be doing it this way and this way and this way. What are the French going to do? They're going to throw you out of the country.
Exactly.
France is the United States, and you're going into the United States in the court, and you're telling this country, the United States, which is different from you, just like going into France, you're telling them how to run their court. You don't understand how they operate in their court. That's the problem. You're trying to get them to make that court like what you want. And it's not going to operate that way because it's not your court.
Right. Makes sense. So where is our enforcement then? I mean, how do you...
Now, if I stop trying to enforce this thing to get them to do what I think they ought to be doing, and I sit down there and study what they are doing, then I can go by their rules and regulations they got in their court, and then we've got this other door that's hiding everything, which is the equitable side. Now, if I can just put on a mask and walk through that without traversing into the case, and then till I finally get to that door, and I can open that door and get into equity. Now I've made a complete circle, so to speak, and I've gone through the gauntlet, this foreign country, United States, France, and did their rules the way they said enough to get into the equitable side, and now I get my remedy, my relief, really.
And I guess that would be the point, really, where you would want to negotiate that instrument into a non-negotiable instrument.
No, I'm not negotiating it. If I negotiate, it's a negotiable instrument.
Right, okay, so I guess tender or what you would call disbursement, or basically when you're turning that instrument into a...
We do a merger and extinguishment of debt.
Right, merger and extinguishment. So you do that pretty much strictly in chambers. Well, no,
in chambers is not where I do it. It's already been done. I just want them to go into chambers and recognize what I've already done.
So it's not necessary to actually turn the instrument into a non-negotiable instrument?
No, it already is a non-negotiable instrument. I don't want to cross it into a negotiable instrument because then I'd be breaching the trust and commingling.
Right. Okay, I understand that. I guess what I'm trying to get to is really writing out that check or that money order.
Yeah, it's not a check. It's not a money order. It's a special deposit. It's an equitable asset, which is totally something different.
Yes, special deposit. So it's not even a money order, special deposit.
Even a money order, no. Definitely not a money order. That's a negotiable.
Non-negotiable, just non-negotiable special deposit.
Yep. Trust receipt. Trust deposit.
Trust receipt. And okay, so trust receipt. So okay, I guess that's it keeps coming all the way around to like I'm trying to understand completely the full process, and you know.
Well, our problem comes in because we got so much of this debtor creditor stuff in our mind. We got to unlearn all this stuff we've learned. That's a real problem. Yeah,
it really is challenging because that's everyone you know. That's all they're indoctrinated, and you know, like Carlos mentioned.
That is hiding the simplicity of NTT.
Yeah, I would like to go see someone like Greg. Greg's in town. I want him to go see him, but then again, I'm like, well, I don't want to get more of this stuff in my head, you know, because that's the issue I'm having. It's like I see what you're educating people about, and it's you're really the only source besides the books, obviously, of how to understand how to operate in a trust form and not in creditor debtor. And you know, I've been reading a lot about it and trying to understand, you know, mostly just going back and listening to the shows and the transcripts, and then Blacks and Bouvier's. So at this point, it's like I'm already in a case. I have to do something. So, you know, and I've already been using a lot of D and C stuff, and now I'm just like, well, I've taken the pill, and I know really it's going to be hard to be really confident in this, you know, DC remedy when you actually know it's all about trust anyways. And you know, you have to be colorable when you're wearing a costume, and then you're wearing a costume on top of a costume, if that makes sense.
Yeah, 90 CJS section 161 says that if it's a trust, it must be treated as a trust.
Yeah, so it's all a trust, so there's really no other thing.
Got to treat it like a trust. Can't treat it like debtor creditor.
Yeah. So I just wanted to put also a shout out to Anonymous, who's also, I think, in Southern California. I would like to, I don't know what his Skype panel is. Do you know what his Skype panel is?
I think it was Freeman Dan, and what was it?
No, Freeman Dan's was a new guy, but Anonymous has been a participant for a while.
G8 or Rick 98.98 or something.
Okay. If he's listening, mine's Organic Cali. You can probably ORGANICALI at Skype. Organic, and then Cali. Okay. Yeah. Great show, though. Thanks so much for your efforts. And
okay, appreciate it. Thank you.
Okay, bye.
Okay, last one. Yeah, go ahead, Chris. Chris, you're unmuted.
Hi, Christian.
Hey.
Let's see. I wanted to go back. Let's go back to the bankruptcy and the adversary letter that I wrote for a person that ordered the court to bring forward all of the assets. That actually did work, and it complements what I found out about the escheatment laws. Is that no one in government or banking can hide the assets that truly belong to the individual, and when you call those assets forward in a bankruptcy act, separate from what we're doing with the merging the titles and whatnot, or even on the public side, when you claim an asset and you order the trustee to execute using the escrow that was originally established based off of the promissory note, and when they fail, they just don't fail you, they fail the state and the federal government under the escheatment laws. And what I found out is that's a non-compliance issue, and it's fraud and defrauding the state comptroller and the treasury of the state with the assets that are unclaimed. And when you come forward and you claim those assets and the banks fail to execute the closure of that, that means that they can be booted out of the state forever.
Okay, all right.
So that was the first thing that that I wanted to say. I wanted to talk to Carlos too. So Carlos, if you're still on the call, maybe when you get done with the seminar this week, and give me a call. I'd like to speak with you for a while. I've been trying to get a hold of you the last few days. Let's see. There was something else. When you were talking about injunctions, can you do an injunction based off of just the notary certificate of non-response?
Yeah, because that's going to create some kind of dishonor against somebody, and that would give you some kind of like unclean hands.
Did you do that like on a show cause hearing with the state level, or do you have to move that to federal?
Show cause for state?
Yeah.
Move federal?
Oh, what I'm saying is can you do it in both? Can you do it in the state level?
Oh, yeah. Equity is still local and state there.
Okay. Do you issue like a mandatory injunction or a temporary injunction or a restraining order? How do you go about doing a show cause hearing on like an unlawful detainer?
Well, then the mandatory injunction wouldn't come until after you won.
Say it again.
The mandatory injunction wouldn't come until after you won. After you won, then you could issue a mandatory injunction.
But isn't it administrative default judgment from a notary? Isn't that kind of like after you won?
Yeah, you really won on the private side, but then you're operating as public venue, getting them to recognize that.
But isn't a notary, and especially if you've done this like 2 or 3 times on the bank and you've given tendered offers, debtor creditor stuff, of course, but you've given them opportunities with the Miller bonds and the several different tendered offers, and where each and every time that you did this, they never responded. They, consistently failed to answer you. Therefore, you've got all these default judgments. Don't you think that that's accumulative and that you can actually use that as a kind of like a
estoppel?
Yeah,
estoppel. Yeah.
So the stock
made offers to settle, and they didn't take it, and that's what you were supposed to do. So you just didn't take the certificates and move forward with the certificates, and because you really didn't know what kind of things you could do with the certificates.
What I found out about the manual that the escheatment law has said is that if they're hiding something, if the banks are between the FDIC and the trust manual that the FDIC has put forth for the banks to actually be in business under their charters, is that it's their duty and obligation is not to fool around with the monies that are accrued on a promissory note. That means that they can't touch one penny. And what led me to the escheatment laws is that any time that there's an unclaimed set of assets, then it's immediately turned over to that particular state, which the state will give 3 years to have that person put claims to that, and there's supposed to be notification from the bank, and there's supposed to be notification by the state to try to do their due diligence to make contact with those people in order for them to put claim to those assets. By us doing the merging of the titles, getting in their face about the assets that actually belong to us, or going to a bankruptcy court and claiming those as our assets, by any failure between the bank and the bankruptcy trustee judge to allow us to put claim to those would be a direct violation to the escheatment laws, and that is reportable as a noncompliance issue to the comptroller and to the treasury of the state and to the federal government.
Yeah, once you had the certify that whatever the dishonor, that could also be, it's the unclean hands, could be just cheat or whatever else. That's the certification of that also.
But have you taken any considerations about how to deal with the comptroller in regards to unclean hands, or being able to dishonor these people, or to get them in a breach of where they're not following through with claiming these assets and zeroing out the trust? Have you given any further considerations of what we're going to do about that?
Concerning what now?
Well, our future. In other words, when we get through dishonoring these people or getting them in a breach of trust where they have unclean hands, and it has to be reported to the comptroller or to the state's treasury or to the U.S. Treasury, these guys are not complying to what the laws say. Have you given any thought of what we're going to do about that?
Well, just like you mentioned before, you do an administrative hearing and invoke a court of equity and make sure you get on the equitable side, on the private side of equity, and so you can put in the information that they've done a cheat or an unclean hand. Well, that would be on the private side. I'd use the equitable maxim for that. But yeah, we come through administratively in these own agencies.
Would you not think that would be doing your due diligence to exhaust your administrative remedies prior to going to a DOJ and filing paperwork, and at least give the state a chance to address an issue like that rather than going to the DOJ?
Giving the state a chance to address it? You mean in a state hearing, a court hearing?
Well, no. My idea is to do everything you possibly can on the administrative before you have to move to court. A lot of people are not very comfortable with court, and so therefore I try to develop anything that I do on the administrative. And since the avenue has opened up that the comptroller is the sole duty and obligation party to all transactions that actually occur within that state, everything right down to the nail that's sold at the hardware shop is all funneled through the comptroller. There's nothing without the comptroller involved with it. That means that they have the sole responsibility to report back to the federal government for exchanges, fraud, compensation, sanctions, monies coming in, monies going out, interfaces with other states and other countries and whatnot, with the investments and whatnot. They are the sole part of all the financial and all of the commerce. It makes sense to me that if you've got a non-compliance issue with a bank not bringing forward unclaimed funds, that a complaint to the comptroller would be in order, that if they verify or they take notation that you've got a complaint that there has been a private filing for the merging of the titles to be completed, and that is not done, then the comptroller would have to take notation of that, of which would back you if you ever had to go to the DOJ in order to get an unclean hands. And it's an administration, and you might get resolved by just going to the comptroller on these issues, by putting an order in to have them bring forward those unclaimed funds, or to do a forensic audit on the bank. And in the meantime, it's an investigation on the bank that's going to get them into trouble if they are in a non-compliance mode with you as an individual upon the default papers that we serve on them.
Yes. Yes. That's my answer.
Yeah, okay, good. Well, I just wanted to make sure I was on track with this, because what I found out today from another group is that, to cut to the chase, what they said, you can, with or without public or private notice, either one, you can use either one, by giving them notification that they're execute the instructions of the grantor to take the escrow bucket that has been reserved, and to apply that against the debt even under foreclosure or any other consideration, is that if they fail to execute that, that is a reportable noncompliance issue to the comptroller, that the grantor instructed them to do something and they failed to do that. And these funds are supposed to be unclaimed. They're not supposed to be in the hands for the discretion or the usage of the banks. It means that the state has jurisdiction over these matters.
Yeah, it's not really that they're unclaimed. It's they're sitting there in trust waiting for somebody, you know, which they belong to somebody, but that somebody's not coming forward and asking for them back or doing something with them.
Well, what do you think about the idea that I had about the bankruptcy and filing that as an asset and having the judge forced to have to call forward all those assets?
Yeah, that's a great idea. Yeah.
Well, would you? How about this? This is something else that we're working on out here, and that is it's called a involuntary recoupment, and it is a. This is so beautiful. It's almost too easy. Involuntary recoupment, with what we found out under the Involuntary Recoupment Act, is that if you were to file an involuntary recoupment, it goes all the way back to the age of majority of 18, and that calls back anything and everything that is reportable to the comptroller that you've ever paid out of pocket, of where they have to pay you completely back for all those funds. And you could do that right just by filing a bankruptcy under involuntary recoupment. And by doing that, they
goes back than that.
Huh?
It goes back farther than that.
I know. In fact, that's what I was thinking this afternoon after I got off one of the calls earlier today about this involuntary recoupment. But it's amazing what we're coming up with. You can actually go back from the first time you started working, if it was 15, 16, whatever you had as...
It goes back than that. It goes back to the first birth of the straw man.
In other words, from the birth certificate.
Yes.
Yeah, but what was mentioned today was the age of majority. That was what was mentioned.
Yep. Yeah, age of majority is not 18. Age of majority is when you have the knowledge to make a choice.
Yeah, I understand that, but they kind of threw me because, you know, not everybody has the same definitions about what age of majority is. And
well,
some people...
Depends on which side your thinking is, because if it's on the private side, it's, you know, when I got the ability to make the choice, I know not to make a general deposit. It's got to be special. Now, if it's on the public side, then age of majority is, say, 21.
Yeah. But what do you think about that? I mean, do you think that that's kind of something to entertain, or do you think we ought to bypass that and just keep moving with where we're going? Or I thought it was a great idea that you can go file a bankruptcy. It's an involuntary recoupment of where you get every penny back that you've ever spent. That's on public record.
Yeah, well, bankruptcy is public side statutes and codes, though.
Yeah, but if you can get a couple $1 billion paid back to you for the last 50 years, I mean, you know, from one point of view, who cares? You got money in your pocket.
No, you can't do it that way. You got to extinguish it. If you don't extinguish it, you're making more debt a creditor. You're mounting debt up and multiplying, compounding debt again. Got to extinguish it.
Yeah, but does that actually put any money in your pocket? That's the question.
You can't do it that way. You got to do it the other way. You got to go come around and go around. Everybody wants to take the microwave way, and that's what commerce has been designed to do. Trick you into doing it now and giving up all your rights.
Well, I hear that. It's just that so many people are in so much financial stress and strain, any relief is going to be better than nothing.
Yeah, well, let's just extinguish our debts, which actually pays them. Let's just merge the tiles and extinguish the debts.
Oh, I'm with you on that. It's just that, you know...
Yeah, but everybody wants a couple billion more so they can go out and buy the Ferrari and the big house and the yacht and everything else and live like a king. No, you just contributed to you just put more debt on my shoulders.
Well, what do you think about, did you happen to catch the document I sent out to you about the special depository fund account that came out of the comptroller?
I haven't had a chance to look at it yet. No.
Now, I got a couple comments back on that, and one of the comments is that on a state level, that's equal to that black card that's on the federal level. And I thought, well, that's pretty interesting. But what it does do is it does the involuntary recoupment of where you can actually go back and reclaim funds. But from what I understood, there was a statute of limitations of 3 years on the retrieval of funds that you've paid out of pocket that were issued the credit by the Treasury Department that are just sitting there unused. That's all you can claim. You can't claim anything other than that. But still, after 3 years, you know, that's got to be, for most people's pocket, that's $20,000+ a year. That's $60,000 you can retrieve easily.
Yeah, but you can't use that money like you think you would and just spend it in a circulation again, because that's what compounds the debt. And you're just contributing more sin on top of everybody else's shoulders.
Yeah, I understand that, and I think that some of the people, maybe some of the people don't, but I do understand that myself.
That's the temptation. It'd be so easy to go right back into the debtor-creditor thing and do exactly what you were trying to alleviate, to stop. If I use that, if I call those bonds and all that debt back, if I put it in, spend it in circulation, if I put it in circulation again, I'm contributing to the problem we're trying to get out of. I got to take, once I get it, I got to merge it and extinguish it.
I've mentioned a couple times this evening, and I've caught you a couple other times talking about easement and surveys, and I've heard a lot of the other groups actually talking about the same thing, about how the different assorted agencies and banks and whatnot are actually trespassing on jurisdiction, and they're actually impersonating and you know, the authority of another agency of where they have no rights to do so. Therefore, they're impersonating another agency's authority, and they're trespassing. But for some reason, they have a free-for-all going on in this country with the banks, of where everybody's trespassing everybody, and there's no boundaries left. You have any comments that you can offer people to catch these criminals that are running rampant with trespassing laws and easements and surveys that they have no rights to do so? I mean, you have any further comments about the easement and survey trespass?
Yeah, my comment is, welcome to Oz, because that's the rules in Oz. Everything's a clusterfuck. Everything's a lie. Everything's a fraud.
Would you say that by setting up your own trust actually sets up the easements of where the trespassers are caught on site, and that you can actually prosecute them because of that? I mean, can you give anybody you know, a little bit of information back on that?
I'm not looking to prosecute anybody. I'm looking to extinguish this debt, get rid of this national debt. Let's terminate the master trust and bring the republic back.
How do you feel about the rural route and how that sustains the republic? How do you feel about that?
Well, I don't think that the UPU is nothing more than public. It's the one world order, and now we're going to bow down to that.
No. That's by claiming the rural route claims the sovereignship, and it claims the republic. It's just the opposite.
I'm afraid everybody is all mistaken for that because they don't understand trust.
Well,
everything is, you think is what it is. Since 1933, it's not. It's the opposite.
Yeah, actually, when you were reading out of the book tonight, I was sitting in the background listening to it, and I thought to myself, you know, I can really tell the difference between what you were reading as being after 1933, or some of that stuff was definitely after 1933, as opposed to how people were thinking before that, because it was so much depth.
If you listen to what I was reading,
huh?
You were listening to what I was reading there?
Yeah.
Some of that stuff is the most garbage, because it says one thing out of one side and it says another thing the same way different out of the other side.
Yeah, and
it was a mix-up of, it's a free-for-all. Everything that I was reading, most of the stuff in this most of the stuff we're reading out of this corpus juris secundum is a free-for-all. You got to have discernment to pick up the little bit of wheat that's in there, separating it from the chaff, that you get the truth from the garbage.
I think that was the reason why I brought that up is because that's the way I read it tonight. I read that there was so much circus act and that everything was going like the Babylon Tower. Everything was going so many different directions that you would really have to pay attention, and you really have to be looking for what you were really seeking for, which is the privacy and what is sovereign and what is the true nature of relations and whatnot. And there was very little and you would have to be an expert almost.
Yes, that's what I'm telling you.
Yeah.
You have to be an expert in discernment to know that most of this stuff I'm talking about is a bunch of fraud. It's all a bunch of lies, and you got to be able to pick out the little bit that's in there that is the truth. That's
true. I totally agree with you. Tonight was a perfect example of just absolutely chaotic information. It was so against itself. I'm just sitting there saying to myself, well, this is not like what has transpired the other evenings with the Corpus Juris Secundum, but maybe it was good for us to be able to tell the difference too. You know, I mean, I can tell the difference on some nights. It's just as clean and as pure as you can get it. But tonight, when you were talking about all these different things about, siblings and the sesquiu and the convolution between relations, and I'm just sitting there shaking my head back and forth. Whoa. Anyway.
That's the education.
Yeah, well, you got to put the time in order to be able to discern, and I think that that's what everybody's here on this call for, is to be able to listen and know the difference between what is the truth and how can you weigh the truth in everything that's being said. Can you wager the truth being said right now at 100% or 50%? Usually, if it's 50%, that's all it is. It's only 50% truth. And I think that a lot of people on this call, they have that quality of being able to weigh things in, and they know exactly when someone's speaking the truth and how much it weighs in for something that can affect their lives or their coherency about, dealing with their lives. So, and congratulations, Christian. No matter what night I come and participate on the calls, it's always awesome. The stuff that transpired tonight was so awesome, especially in and around the injunction information, and even with the traffic ticket that who was that had that traffic ticket? It was
Floyd.
Yeah, you really worked that, and it was just clean. See, I can really tell you that those were the pockets of where, with what you knew, came through so crystal clear, but with what the Corpus Juris Secundum was saying was not as clear as most of the rest of the call. So anyway, that's it for me. I didn't mean to occupy so much of the time, but I think that we've got some really strong possibilities coming up with bankruptcy and the comptroller. If the comptroller knew that we're getting in the faces of the bank and they're not complying, you only have these banks taken out of the state before they all start coming into compliance.
Yeah.
So we can do that. Anyway, I'll let you go, and if there's any other callers, you can go ahead and take those, okay? Thanks for everything.
Okay. I think that's about it for me. Oh, Frank? Yeah. Okay, Frank, you're unmuted.
Yeah, hello.
Hey, Frank.
Hey, did Harold ever come back?
No, I hadn't heard him, no. I'll ask him.
All right, I was looking for that, for, others that can't manage or can't understand and would be beneficial to talk to, one of the other side who has come over, So that was.
I think this guy's funny. So he hasn't come over that far yet.
Yeah, right.
He still wants President notes, I think.
Right. And what is the way to get to Chris's website?
I don't know if he still has his website, that lawlearners.org, I think it was.
Is that what it was?
I believe so.
Okay. But he posts most of his stuff on your website, though, doesn't he?
No, I don't have my website anymore just yet.
For shared, no?
Yeah, that's still up, yeah.
He was speaking of one document or instruction manual on the transfers that attorneys had put out for the UCC. I wondered if that was posted.
The transfers on the UCC.
Yeah,
that's part for the merging the titles, you mean?
Well, he was just saying that the attorneys had put one out for using of UCC documents. So that was what I was curious about. You know, I guess it was for transfers of one part of it.
Yeah. I don't know. I was thinking it was that the notice that we had, but no, I don't know.
Okay. All right. Until tomorrow, Almighty Bus can protect again. Maybe they'll come on and fill us in still.
Okay. Well, I'm getting tired, so we'll be here all night. That's the last one tonight, so. All right. Well, I thank you all for joining me. See you Monday at
Thanks for having us.
10 p.m. Lawlearners.net, Frank.
Okay. Thank you.
All right. Thanks.